Today's copy in the list, page 1, item number 1 to 8.
Item number 3, I may be permitted to remove the defects as pointed out.
That the matters be listed on 4th of October 2023. Here, Mr. Raut,
Yes, ma'am.
at the request of Mr. Niranjan Raut and counsel opinion for the petitioner. Meanwhile, the defects is identified and the verification shall be removed.
Item number 2, permitted to remove defects, my lord.
Defects,
My lord. Item number 2,
here, Mr. Pradhan,
my lord.
BP Pradhan,
Be because-
just change the name, same order, same date. It will come again on 4th October.
Page 2, item number 9 to 13. Page 3, item number 14. Page 4, item number 15 to 20.
Item number 15, on 28th August 2023, similar matter, to 26th of September. This is the lordship. This is same matter, then carried out following that.
As it has been stated by Mr. Tripathi, as stated by Mr. B. Mohanty, B. Mohanty, learned counsel opinion for the petition. No, just it has been stated by Mr. B. Mohanty, learned counsel opinion for the petitioner that analogous matter is fixed on 21st September 2023. That this matter also be listed on 21st September 2023.
Okay.
Within the 5, no? Yes,
Pardon to mention, but one assignment of
his
court,
mention is over. His mention over.
but assignment of court number 1, new building. Since Justice Misra concerned with the matter, therefore it has released from the board. Since matter is urgent, may be taken up Monday.
What is the matter about?
The matter relating to management of a religious institution, a temple. Huge number of public, there is a tussle between two groups, my lord, in the locality.
All right, we'll take up.
My lord. Grateful, man.
Monday.
Well, this
Number 576 of 23. Yesterday, item number 23. That's not put out that matter for consideration of the citizen charter.
Hmm.
That's not this matter.
You have to check up whether we asked any order to list today.
Date has been fixed to another date,
Date has been fixed.
October.
October 16, by that time, it will be become. They are by taking advantage of the significant charter. They are doing on constructing the building which is the subject matter of the.
You are not there when we are just fixing the dates.
Consideration of the.
Just take for the IA matters, just take only the IA matter will be listed on placed in the list.
Pardon to mention, your lordship, jail criminal appeal 58, but
Just a minute. It will come on 5th. Yes.
well, this is a matter relating to appointment of RSC scheme. Your lordship, 30th last occasion, 30th batch of matters were fixed to 4th September, my lord. So let it added to that matter, my lord.
Give one connected case number.
Connected matter, I will mention it. Writ appeal number 18110 of 2021.
All right. It is mentioned in the memo. It is mentioned in the memo.
Yes, ma'am, I mentioned it, and I also underline it.
May I mention, my lords, one very serious matter, my lords.
Huh?
Very serious matter, serious concern, of course. My lords, MKCG Medical College, my lords, Barampur. My lords, students are reading. They are subjected to serious ragging. Of course, after my drafting of the writ petition and filing it, I learned that a guard being molested, this first year student being molested by these senior students, and somebody has beaten.
When have you filed this petition?
I filed these petitions at 3 days before, 4 days before.
Bring the record. We'll take up today right now. You take Mr. The learned counsel.
Yes, my lord,
Mr.
WPC.
Muduli, we are taking up the matter.
28234 of 2023.
Just to find out this entry again. UGC's anti-ragging act, you find out from the.
Today,
Just search, they will not get it is university.
I was taking up the matter today, my lords. Not to,
Immediately after the board is over, we'll take up the matter because so that they can also go through their brief.
my lords.
Have you served the copy? Of
Yes,
the
yes, we served the copy, man.
As soon as the list is over, we'll take it up.
Take it up. My lords, will I pray my lord tomorrow?
Today.
Today.
My lord,
Today itself will take up.
I may be pardoned to mention, this matter was directed to be listed on 31st, but yesterday it has not been listed,
Fifth.
in spite of the order of this honorable.
my lord, my lord, my lord, jail criminal appeal, my lord. 2013 to till now, they are spending in the jail custody 10 years, more than 10 years, my lord. So it is maybe listed for Friday, my lord. Jail criminal, paper book also ready. I have
Case number.
50, jail criminal 58 of 2013, my lord.
All right.
I may be pardoned
It
to
will come on the next week.
Yes, my lord, obliged, my lord. My lord, without.
I may be pardoned to make a small mention, my lord. Writ appeal number 1289 of 2023. My lord, the present appellant is the OPSC, my lord. My lord, appeal against single judge ordered judgment, my lord, dated 1/5/2023, wherein the learned single judge has passed an order for taking the petitioner as a vision impairment. My lord, may I pray the matter for
Why?
Monday?
What is your problem?
My lord,
Someone visually impaired, what is your
my
problem?
lord, that doesn't fulfill the criteria of the OPSC, my lord. For that, my lord, OPSC has come in a writ appeal, my lord.
33 of this act,
My lord,
section 33 is a clear statutory mandate. How the OPSC
my lord,
can have
the
different
present post is not for the selected category, my
All
lord.
right, it will be listed tomorrow. Bring the roster of the OPSC.
My
We
lord,
like to see the roster. If there is no roster, we'll just confirm it tomorrow itself.
my lord. Grateful, my lord.
Pardon to mention, Lordship, writ appeal number 1352 of 2022.
Yes.
It was for listing on 31st of August, but it was not listed as a pension matter, Lordship.
Already list someday because it is a pension related matter. List on this. It will come on 11th of September.
Excuse me, Lordship.
11th of September.
11th. Monday.
Early.
Early.
It's difficult to early because all the list on Tuesday. Let us see. Tuesday. But if we find any defect in the appeal, we will not grant any further the relaxation of the. You just check up whether any defects are there.
Sorry.
Whether any defects are there, you just kindly check up and remove the defect because we are fixing the matter.
Lordship, I have removed defects.
All right. Come on 5th. Let us see.
My lords, two writ appeals.
You file a memo
Yes.
right now.
My lords, two connected writ appeals. Writ appeal number 431 of 21 and writ appeal number 608 of 21.
Yes.
One has been referred by the Talcher municipality and one has been referred by the state. The Lordship, after hearing the matter, directed for listing that on 25/8/23. The same has not been listed. The same has not been listed, Lordship.
25.
It was specifically posted to 25/8/23.
Let's check up given Tuesday. List the matter Tuesday. Check up why the matter has not been listed. Check up why the matter has not been listed. You got it? Stated in the regulation is
Which any date? Any
5th
date?
September.
5th September. My lord. Oblique.
Sir, this is Mr. PL 16195 on an ongoing project. Sir, I also filed the I 12987, but for the second time it is also adjourned to 9th October.
When the date was fixed,
Sir, it is actually it was on 25.
You are not audible. Come to this audio device put before you because you are not audible.
Mic ପାଖକୁ ଆସି କୁହନ୍ତୁ ଶୁଭୁନି ଆସ୍ତେ
Um,
ଆସ୍ତେ
Um, sir, am I audible, sir?
Ah, yes, yes.
Sir, actually, this is 6195 a PIL on an ongoing project.
6195 of 2023.
Sir,
Hmm.
sir, for the first time it was adjourned to 21st September.
Ah,
It was listed yesterday, but for the second time, it is also adjourned to 9th October.
is it that bridge construction matter?
Yeah.
all right, you come tomorrow. We'll fix up the matter tomorrow.
What time, sir?
Tomorrow.
Okay.
Tomorrow there is a special bench, though it is a Saturday, so we'll take up your matter.
Thank you, sir.
Yes.
Second list, page 1, item number 1. May it please, my lord, my lord, I may kindly excuse, I am in
Yes,
this
Mr. Mohanty. Yes.
because of a personal illness, my lord, I am in BC, my lord.
All right.
Lord, this writ appeal is preferred against the Honorable Single Judge orders, my lord, wherein the Honorable Single Judge, without appreciating the matter, held that it is a dispute regarding dues, my lord, and allowed me, refused to entertain the matter and told me to raise a dispute under section 68 of the Cooperative Societies Act, my lord.
Yes.
My lord, the entire case of the petitioner was that under a scheme in 2008 of the central government and Nawad, my lord, that is at page 51, my lord, the exemption was granted, my lord, by way of subsidy.
Okay.
The scheme clearly stipulated by a circular that if you pay the principal amount, rest of the amount will not be recovered either from the state government or for the central government or from the loan miller.
Yes.
And I deposited the entire principal amount, which is admitted also in their counter. But
Is there any standing counsel for the cooperative? You are appearing.
No,
my
no,
lord,
no,
notice
no,
has to be issued.
All right.
I'm only accepting notice for opposite party number 1.
No,
But
this
2
is
and 3 notice has to be
This
issued.
is a formal party.
OP1 is a formal party, yes.
Yes.
case 38, my lord, they granted me the NOC. Subsequently, after 12 years, they told that you are a defaulter and rejected my nomination, my lord.
All right. Heard Mr. Who is assisting you, Mr. Mohanty?
Mr. Ratho, my lord, he is also in BC, my lord.
GM Ratha.
Heard Mr. A. Mohanty and senior counsel, issued by Mr. Gauri Mohan Rathod and counsel for the appellant. There is an intercourt appeal challenging the order dated 22/6/2023 passed by the learned single judge in WPC number 8573 of 2022. Stop. Mr. Mohanty learned senior counsel has submitted that learned single judge, without considering the very nature of the controversy, has reverted the appellant back to the jurisdiction of the
Registered cooperative.
registered cooperative society. Stop. According to Mr. Mohanty, that mere existence of the alternative remedy doesn't universally prohibit a person from approaching this court under Article 226 of the Constitution of India. Admit to be heard on merit, issue notice. Mr. A.C. Behra, Mr. Arnav Behra, learned additional standing counsel, appears for the respondent number 1. Stop. The appellant shall take steps for service of notice on the remaining respondent by registered post with AD within 3 working days from today. Notice is made returnable on 9th of October 2023.
Lord, I have prayed for interim stay of demand notice dated 2/12/2021. It was stayed by the Honorable Single Judge initially.
Since we have admitted the appeal challenging the order dated same order, no? So since possibly the single judge and has admitted the matter and taken up the matter for further consideration, the demand notice dated 2/12/2021 issued by the respondent number 3 shall remain suspended till the next date. So meanwhile, the opposite parties number 2 and 3 may file their objection if any against the prayer for stay.
The requisites will be filing by Monday.
All right. 3 working days.
Sorry, I please.
If your lordship permission, my lord, one small prayer I have wrongly mentioned in a memo that is fixed to 4th. It is not 4th, 14th, my lord. Instead of 4th, it is 14th. It will come on 14th.
14th, huh?
Yes, in
they just ask the number and then correct it.
readable number 8010 fixed to 14th. My wrongly stated in 4th. 14th.
For the next matter.
Item number 4.
CPIL challenging the unlawfully demolishing the school building and going to build a 5T under 5T scheme high school over a Gochara land. Though
Earlier school was not on Gochara land.
ME school has existed there. ME school more than 200 students are there. Now there is no classroom to sit.
That is
That was the Gochara land.
My precise question, Learned Council, please appreciate whether the earlier school building was on the Gochara land or not.
Earlier school, that was ME school, not high school. Now high school is going.
Whether that school was on the Gochara land or not.
Yes, my lord.
Then
now new high school is separate, ME school is separate. High school, though high school have sufficient own property.
Functioning of a ME school over Gochara land, not the high school. That is because this school, according to him, it is.
Now high school building.
Now it is transformation is going on.
So you don't want a good school in that area.
No.
That is
high school have sufficient land and property own. Now they are going to construct the building over that Gochara land, which is unlawfully, and villagers are now facing a lot to use the government land.
It is not understandable to us. We are challenging when a good thing is going to happen. Gochara land is not that cannot be de-reserved. That can be de-reserved for the public purposes.
Gochara land is there. They may construct the ME school.
Literally, the school was running over that plot, but in shape of a ME school. Now, according to the petitioner, a high school is upgraded there and going to be. He is claiming that this is a Gochara land, but that Gochara land was used for school purpose since long.
Maybe probably field may be being used. Gochara land as field, but what about the students who are studying? If that
should have been taken care of. That is not allowed. That
is not your grievance.
That is not there.
You're saying that the students
only
don't have
Gochara. Only Gochara is the grievance.
Who is constructing that school?
Under 5T scheme.
5T scheme is a government scheme or not?
That is a government.
Opposite party 2 is responsible. Opposite party 2 instructed to.
Opposite party 2 is not the government. Then?
Video.
Collector.
They didn't allow the school,
You are Mr. Mishra.
construction in Gochar land.
You are
They
Mr.
allow-
Mishra.
They allowed to construct.
All right, you are Mr. Mishra.
Nahi, BC Ponda.
All right. I heard Mr. BP Pradhan, Learned Council appearing for the petition.
Ponda.
BP Pradhan,
BC Ponda. Bharat
you are not on record. Have you filed the Vakalatnama?
Yes,
He is
SC
there.
Behra. and
Second person also. Arjuna Charan Behra, BC Ponda. Item 4.
Oh, I'm sorry. Heard Mr. BC Pandal and Council appearing for the petitioner.
Sufficient landed property to own. They will construct there.
So, the petitioner is a public spirited individual and filed this public interest litigation in order to protect the Gochara land from utilized for any other purpose, including the construction of the school. It has been stated in this petition that by demolishing the Kathiagadia Nodal ME School, the opposite parties are going to construct 5T High School over the land of the said Nodal ME School. The petitioner had requested the collector, Balashore, for directing the block development officer, Khaira, for inquiry and not to allow the school and mass education department from constructing the 5T High School over the land of the Nodal ME School. But the collector has not taken any action. In the said prospective fact, this public interest litigation has been filed, urging this court to direct the collector Balashore to stop the construction of the said 5T high school over the Gochara land.
Also, Alexa 3.
Gochara land
There is no
comprised in
page.
plot number 1543 and Khata number 454 of Mauja, Kathiagada, under Khaira police station. From the very facts adverted by the petitioner, it is apparent that the opposite party number 3 is utilizing the land on which the ME school was operating since long. And on demolition of the old structure, the new 5T high school is coming up. Therefore, the bona fide of the petitioner is highly questionable, and hence we dismiss this petition. Stop. Mr. D.K. Mohanty, learned Additional Government Advocate, has appeared for the opposite parties.
The Lordship has issued notice.
We have dismissed the petition.
Dismissed. Obliged.
Yes, next.
I.
Rice mill, which the entire area here, that is, so that we have also made a difference in the collector, indicating all those checks. But one of the basics, and it was, they have given that because of the establishing that field, because done, from the also controllable. The rights in the established the village, also the entire area. That is the matter of becoming the collector. Now also this regional concept for policy state control pollution control regularly taken up.
What is the pollution rice mill can produce?
Because rice mills are there just because of the poisonous smokes and other things.
Smokes in a rice mill. Have you seen any rice mill ever? I am asking you, counsel, not the petition. Have you seen ever a rice mill?
All kinds of rice mills, but they are.
You have not seen. That is why this is an improbable the prayer you have made. It is basically this is a big husking machine, nothing else. It's not done. This is not done. Everything. Chittaranjan Patnaik and council appearing for the petition. By means of this public interest litigation, petitioner has asked this court to make an inquiry to shift the rice mill established over the plot number 195 and 188 of Mauja Budupulli under district Subarnapur. As according to the petitioner, a rice mill is polluting the village air. Stop. Those who have a little knowledge about the functioning of the rice mill will realize that this allegation is far-fetched. In terms of the above, this petition stands dismissed. Mr. Arnav Behra, learned additional standing counsel, has appeared for the opposite parties, number 1 and 2. You just once visit the rice mill, then you come to this court. Don't always believe what your client says. That is that was next.
Item number 6.
Yes, Mr. Mahapatra.
What was being convicted, the commission of offenses of section 498
Yes.
section 34 of the Indian Penal Code and on section 4 of the Doubt Prohibition Act. So far, for each condition, he was awarded life imprisonment. I will make it clear, my lord, that there are 3 appellants. Parents, those who are also equally convicted on that section, they were enlarged on bail on favoring the court. And so far the petitioner is concerned, my lord, bail application was earlier rejected by my lord. And in the mean period, the petitioner has spent 4 years, 9 months behind the bar.
Yes.
I would like to bring my lord's kind attention that out of the wedlock a son was born. He was then a kid when the deceased died. And thereafter now the son is 15 years old, prosecuting or study in class 10th, my lord.
Yes.
And the parents, those who are released on bail, they are now advancing their old age. Father is 82 years and mother is 72 years, my lord. So in view of this background, I renewed the prayer before my lord for reconsideration because the appeal is not likely to be taken up for hearing. So far the material is concerned, my lord, admittedly marriage is within 7 years, there is no dispute, and the death is unnatural, that is born injury, death was there. But so far the component of the allegation of ill treatment or harassment soon before the death of the deceased, that is lacking. Why I am saying so, there are...
Get the matter on merit. If you are so that your entire appeal is on that, whether this element of the soon before the death and the harassment for the dowry has not been properly proved by the prosecution, just argue on the point, you'll just hear the main matter.
My lord?
We hear the main appeal. Why?
Yes, I am ready for that. If your lordship permit, I can. participate in the-
It will
Provide
go to
the
the other assignment.
Deposition copies. I don't have the deposition copies. My land senior can provide the deposition copies.
Hmm. What is the question? He says that under section 304B, most essential ingredients are the soon before the death. There was should be the harassment for on demand of dowry. That has not been proved. And this is not a case where the section 313B can be attracted. That is the grossly what I have understood from the. So there is no question of presumption because the occurrence took place after 7 years of marriage. Am I correct? Within 7 years, up to
Within 7 years.
so then the presumption would be there.
My lord.
The presumption will.
So let my land senior give me the deposition copies.
Have you annexed the order passed on the last occasion, rejecting your bail prayer?
That is the order dated.
Order dated 7/8/2020.
Yes, 2020. 7/8/2020.
Where is that order? Mr. Kotukia, do you have a copy of that order?
No, I don't have the copy.
No. Order number? Order number 7 was passed in 2020. That is the last order, 2020 order, 17th August, 7th August order. On the consideration of the COVID only. No, is it there? I'm saying this. That's all right. COVID situation also, it was very risky. When he was arrested, when this applicant was arrested, when the applicant was arrested,
25/5 of
2000,
sorry. He was on bail during course of trial. He was taken in custody after the pronouncement of the judgment. That is on
sometime in 2019.
16. Arrest date, my lord, is 21/5/2008. Thereafter, he was released on bail during course of investigation and trial. After the judgment was passed, he was taken into custody on 1/12/2018.
Just we are fixing the matter on next Wednesday for consideration of bail. Before a bench comprised of Justice Ratho. All right. Let the matter be listed before a bench on Wednesday. Give the date only, not Wednesday. What is the holiday? On no, 11th September it will come. 11th September. It is Monday. 11th September, no. 13th September, before a bench in which Justice Ratho J is a member for consideration of the bail application. In respect of, is the appellant number 1?
Appellant 1.
Appellant number 1. Stop. Mr. S.C. Mohapatra, on a senior counsel. You are Mr. P. Mohapatra. Registered by Mr. S. Mohapatra has appeared for the applicant. And Mr. J. Kotokia, on an additional government advocate, is appears for the state. So it will be coming on that day, 13th September.
11th.
13th September.
If my friend requires, I will supply the xerox copies of the evidence.
And Mr. Kotokia, that bail was granted to the other person.
It is because both are elderly person,
Consideration.
elderly person due to COVID situation.
Come out preparation, because I got the submission of Mr. Mohapatra wrong. I thought it is beyond 7 years.
No, it is within 7 years.
All right.
That's sorry.
So the section 113B will apply if there is some materials regarding harassment. Okay.
Number 7.
May I please, your lordship?
Yes.
Well, here the petitioner's prayer is to get appointment under the rehabilitation assistance scheme, my lord. Well, the issue here is whether the rule which was prevalent at the time of date of the petitioner's mother will be applicable or the new rule, my lord. Your lordship has already decided that issue.
Now, they released the matter on 4th September 2023. It is fixed, all the matters we have fixed on 4th September.
Yes, ma'am.
Mr. K. Swain and counsel appears for the petitioner, and Mr. M.K. Kunjal and national government advocate appears for the state of the respondents. Right.
Grateful, my lord.
Item number 8.
In this case, the petitioner filed a miscase seeking withdrawal of the case because the matter relates to promotion. The post is going to be upgraded because of career restructuring, and his grievance can be redressed by that way.
Therefore, you are not going into all this matter.
All right.
Mr. S.K. Swain, learned counsel appearing to the petitioner, has submitted that he has instruction to not press this petition. Accordingly, this petition stands dismissed as not pressed.
9.
Nine months, there is a delay of 90 days. And this matter can be fixed to that 4th September, is a rehabilitation assistance matter. This matter can be fixed to 4th September.
Relating to the rehabilitation.
Yes, ma'am. This is the matter relating to that.
All right. Release this appeal on 4th September, as it has been stated by Mr. M.K. Kunjal and additional government advocate that this matter relates to the rehabilitation appointment, and more particularly on the aspect of the date of consideration.
Well,
similar matters are there on that date.
Pardon, my lord. My lord, in this case, my lord, I am appearing on behalf of the respondent number 1, my lord. Today I am appearing.
All right. Mr. Say your good name?
No. B. Bansidhara Satpathy. B. Satpathy.
Mr. B. Satpathy, learned counsel, appears for the respondent number 1.
1.
All right.
if he needs a copy, I can serve him in course
copy.
of the day.
Copy may be served.
I am submitting that. If you need copy, I can serve.
That is obvious. Obviously.
All right, you exchange. There is no difficulty. Exchange it. Yes.
I am just serving now.
Yes.
Item number 10.
I am for the respondent.
Yes.
There is a delay of 65 days, my lord.
Are you opposing the delay?
But matter to be finally heard, my lord, because I am ready in the final hearing also. But there is no question, my lord. It was based on the documents the honorable single judge allowed, my lord. Regarding
that
only
will do, but
eligibility.
first we just this allow the delay.
My lord. My lord.
Have you filed the certified copy?
No, I have filed that Xerox copy. I will file that.
Already. First take the IN number 4868 of 2023. Mr. M.K. Kantiel and additional government advocate appeared.
That I
appearing
have
for
filed that
the
online
appellant.
copy, online judgment, madam. I filed online copy judgment.
Appearing for the appellant applicant. We start with hard. No? Stop. This is an application for dispensing with the filing of the certified copy of the judgment dated 12/5/2023, passed by the learned single judge in WPC number 4766 of 2019, which has been challenged in the WA number 18022 of 2023. So, Mr. Kuntial and additional GA has stated that he has filed the downloaded copy of the said judgment dated 12/5/2023, but for urgent filing, the certified copy could not be obtained and filed with the memorandum of appeal, and hence this prayer has been made. We find no difficulty in allowing the said prayer by dispensing the filing of the certified copy along with the memorandum of appeal. Stop. But the appellant shall file.
We have filed already. Now that the online judgment that is able, that we have filed that.
That's all right.
No, not downloaded. That is not downloaded. That is the online judgment that we are getting that in shape of that certificate.
No, it's all right. This is a downloaded copy only.
Yes, madam.
But your rules prescribe that you have to file the certified copy. That we have not already done.
I will file, madam.
That within 30 days,
Madam.
the appellant shall file the certified copy of the said judgment for the court. Hence, this application is allowed in this post of. I'll come to the next. This application, hard substances. Also, Mr. B.S. Tripathi, Plant Council, appearing for the opposite party. So this is an application under Section 5 of the Limitation Act for condoning delay of 52 days in filing the intercourt appeal from the judgment dated such and such pursuant to the same judgment. So Mr. Tripathi Learned Counsel at the outset submitted that with an expectation that the appeal would be heard expeditiously, he would not oppose the prayer for condonation. So we have perused the causes assigned for explaining the delay. So it appears that the applicant / appellant has made out a case for condonation of delay. Accordingly, said delay of 52 days stands condoned. And the results, this application stand allowed and disposed of. He has come to the appeal now.
Yes.
The lordship can fix it to next week any day.
I have objection. I have objection because
Your lordship can fix
service
it to
period
next
just
week
for
any day.
nothing.
All right, tomorrow.
Yes, ma'am.
My lord.
Tomorrow.
The appeal tomorrow for consideration.
Well, deep reply.
11.
May I please file petition for condonation of a delay. Judgment was passed on 3/7/23. Writ appeal was filed on 21/8/2023. Even though I made application for certified copy on same day on court, but certified copy made available on 24/7, my lord.
Okay. So only 17 days delay. It can be condoned, I think.
There are two private opposite parties.
Opposite
party number 4 and 5.
So the formal notice has to go.
My lord.
Heard Dr. J.K. Linka, Land Council appearing to the appellant's land applicant. This is an application under Section 5 of the Limitation Act for condoning delay of 17 days for filing the intercourt appeal from the judgment dated 3rd July 2023, passed by the learned single judge in WPC number 18225 of 2022. Stop. Issue notice as to why the aforementioned delay shall not be condoned or any other order shall not be passed. Since Mr. P.K. Padi, Learned Counsel, Deputy Solicitor General of India, appears for the respondent number, the opposite party number 3, and Mr. Arnav Behra, Learned Additional Standing Counsel, appears for the opposite party number 1 and 2, and waive notice. No formal notice is called for. The applicant shall take steps for service of notice on the opposite parties, respondents number 4 and 5, by registered post with 80 within 3 working days.
My lord.
Notice made returnable of 9th of October 2023.
9th of October, early date, your lordship, kind. In September, your lordship.
Huh?
In September, yeah.
Then on 27th of September. All right, 27th of September.
Because notice will go into Kotak and Bhubaneswar, so far private party is concerned.
Registered post, that sometimes it creates difficulty.
My lord, I'm sorry. Your lordship issued notice only on miscase, IA or both?
Only on IA. That cannot be issued unless the delay is condoned. Yes.
12. My lord, may I please? Well, this is a single bench matter, my lord. Lord, this is a single bench matter, my lord. But noting is, my lord, second copy has not been filed.
What is your prayer?
My lord, your page 42, my lord. Page 42, the standard operating procedure dated 14/11/22.
All right, I think Mr. Kuntia is right. Some operating procedure is being challenged. Is not a rule. Operating procedure is a guideline.
My lord. I have challenged that has not been consonance with the rules, man.
That in some cases where that rule has, virus of that rule has been challenged, they are also prayer in that to challenging this.
No. According to him,
but this is a single bench matter.
This only the operating procedure which has been framed according to you, it is in contrast to the rules.
Yes, my lord.
The rule are not challenged.
He has not challenged. In this case, he has not challenged.
These are in contradictions to the rule that should be.
Yes, my lord. Yes, my lord.
Treated arbitrary and
same.
That's all. It is agreed by the council for the parties that this matter relates to the single bench, and as such, it is remitted to the bench assigned with the subject matter for consideration expeditiously. You are Mr. Purida.
My lord?
You are Mr.
Mohanty. B.
Mohanty, Learned Counsel, has appeared for the petitioner Mr. M.K. Kuntia. Learned Counsel has appeared for the opposite parties. You just one is read the draft. I just mentioned I read draft. All right.
13.
All right.
I don't think any objection has been filed. No objection. Then notice has gone.
Process served.
Just appeared.
So the number of parties are used. Everybody has received the notice.
And the thing is that there are so many substitution petitions have been filed. And those have been single line.
There's a order on Sujay which have allowed him and filing 24 to 21. 24 to 21. Respondents have appeared to Mr. Karan.
24 to 21.
3, 4, 6, 7, 8, 10, 11, 12, 13, 14, 17, 20, and 21B.
Is it order of the court or the registry? Because I don't find any. What is the case number? Is it WA 510?
I will repeat see because should be seeing the order dated 24 to 20.
It is what? Which item? I'm seeing 13. There is an referring an order. That order is not available on the.
But when Lundford says that he has not appeared for all, some respondents.
Limitation and
Just you check up. I'm adjourning the matter. If there is any problem with the process, because it is a very not clear also registry's report. Who have received or not. They have not done that actually. This is a service.
that Bhakalatnama filed for 3, 4, 6, 7, 8, 10, 11, 12, 13, 14, 17, 20, 21B.
You give the numbers again?
That opposite part number 3, 4, 6, 7, 8, 10, 11, 12, 13, 14, 17, 20, 21B. I am appearing for that.
After 13, 14, 17,
Affidavit filed and Bhakalatnama filed on 2/2/2021.
13, 14, 17,
13, 14, 17, 20, 21B.
21.
21B.
Yes, 21B.
When, Mr. Sahu? When?
But it is on 2/2/2021.
But there's a noting on 17 to 21 that you have not filed.
Other than saying.
Page 15. Have you filed thereafter?
My brief shows that we have filed on 2/2/2021. Your Lordship, kindly adjourn it. You will verify the record and.
Oh, there is.
Let the matter be listed again on 25th of September. Yes, this month.
There is a Wakalatnama.
25th of September. Stop. Registration
That
report.
25th, I will be absent.
Will the service of notice.
Can you do on 26th? 26th.
Filing of Wakalatnama by the council.
On 26th.
Wakalatnama is there.
26th.
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 There is a Wakalatnama on 2nd February.
Yes,
Okay.
ma'am.
Office
2nd
note
February
is
we have
long.
filed.
Of all these persons.
No, that he has to verify because
Just
Yeah, I have to.
Wakalatnama party is just obliterated. Stop.
While Lundford was appearing for the respondents in the restriction. If you can get the Wakalatnama in the meantime, that will solve the problem.
no, the
Yeah, I will try,
person
I will.
said he has filed a Wakalatnama.
No,
Office note
not-
says not filed. Others, others,
Because
The left out respondents, I will try.
find out.
I will try
all the respondents in the restriction.
in the meantime.
You can appear then, I think. And now that is why you are also asking who has filed the Wakalatnama.
Mr. Ramakanta Mohanty, London Senior Counsel, listed by Ms. Sumitra Mohanty is with you. Sumitra Mohanty is with you. How is Sumitra Mohanty? Appears for the the appellants. Stop. I am not reflecting your name, Mr. Sahu. You have filed the wakalat now.
Yes, yes.
Yes, I have filed. Mr. N.K. Sahu, Land Council appears for, then I can record you. He appears for the response number 3, 4, 6, 7, 8, 10, 11, 12, 13, 17, 20, and
12, 13,
21B.
Yes.
21B. Stop. The registrar's report therefore shall be confined to the remaining respondents. As to their service or any other counsel, whether any other counsel has appeared on behalf of those remaining respondents. Let us see also. You also check up that any problem is there.
In the meantime, if there is development can.
Yes, yes. I will try.
Then no problem.
Yes. Along with the Sumitra.
Yes.
I don't know, 14, four guys, that your lordship's order dated 11/8/23. Not be possible to comply that, but kindly grant further good time because reasons, administrative reasons.
It has not been complied with.
For 7 and 8. Municipal municipal.
That's somebody up here.
You have not done the assessment as yet.
It could not be possible. Administrative rules further time and kindly grant.
Let the matter be listed on 18th of September, 2023, in order to enable the opposite parties number 7 and 8 to comply the order dated, comply our order dated 11/8/2023. Mr. D. Mohanty, counsel appears for the petitioners. Mr. D.K. Mohanty, additional government advocate, appears for 1, 2, 3, and 4. And Mr. P.K. Paul. And none appears, Mr. P.K. Goyal and counsel appears for opposite party number 9. You are there, Mr. Pari.
Yes, sir. We are not the party, but wrongly my name is reflected.
Mr. P.K. Pari, the Solicitor General of India's name shall not be reflected in the positive because he is not representing any party in this proceeding. All right.
Drainage is essential, so far as the BIM has to consult the.
No, that we have asked them to make an assessment that they have not done. They wanted a 15 days time that we have granted. Matter will come again on 18th.
16.
In item 16, I mean VC for the petitioner, my lord. And this is a case with regard to the espionage which took place at the Integrated Test Range Center at Chandipur, Baleswar, my lord. Here now what has happened as per the affidavit filed by the state government, the charge sheet has been filed under various provisions of IPC and the office and the Official Secrets Act, my lord. But here the question is, as far as the documents are available, in fact, the state has also admitted that the persons involved are of foreign origin, my lord, particularly of the ISI agents, and the money has been transmitted from Dubai. So if this is so this needs for further investigation by a specialized agency like NIA or CBI.
The Right to Information Act.
My lord, your lordship may kindly see the last order. In the last order, your lordship has directed me to file affidavit. What is the status of the case? Then I will draw your lordship's attention to the affidavit dated 7th August 2023, filed by the IO.
For SPCID.
What my learned friend is saying that stage has already over. The matter is under trial. Many witnesses have been examined. I have given the exact status of the case in my affidavit.
The 8th August affidavit?
7th August.
Oh, you have filed it on 8th August anyway.
Affidavit of Jibanananda Jena, working as inspector
yes.
CID.
Have you gone through that, Mr.
Yes, my lord. I've gone through that.
Now the case has been transferred to CID crime branch. Crime branch, after submission of charge sheet, the court of sessions is now in the session of the matter. The session judge Baleshwar.
No, my submission would be, my lord, if your lordship will see page 4 of that affidavit, they say that the investigation is closed and the trial is pending against 4 or 5 persons. But my point of concern is because here the case is involving foreign nationals and that too ISI agents, and how can the case be so soon be closed and trial be started, my lord? What have they stated in the charge sheet with regard to the foreign agencies, my lord? Let the state government clarify to that fact, because I don't have any personal interest as far as this matter is concerned. I'm concerned with the national security, my lord.
Question is somewhere else.
Yes, my lord.
That this is a statutory proceeding is going on, and if you have the information with you, which may be relevant for the investigation, go to the IO, submit those investigations. They will further investigate the matter. And if you say that do not have the jurisdiction, that question can be raised separately.
That is the only concern, my lord, because
the jurisdictional objection is not there in this application.
No, actually,
you want only the disclosure.
No. In fact, if your lordship will see,
read your prayer, Mr.
Yes, my lord.
Read your prayer.
Yes, my lord.
My lord, may kindly see the prayer. Initially, this prayer was made. That was not entertained, and the crime branch has submitted the report. And charge sheet. Trial has already started. Many witnesses have been examined. Now he is trying to reiterate this prayer, which has already been not entertained by this honorable court.
Actually, what has happened when
at this stage, how can this submission be accepted when the court matter is sub judice in a competent court of law?
Yes.
Your lordship may kindly see the order dated 7th of December.
Come to prayer. We will not go anywhere. Come to the prayer, Mr. Acharya.
Yes, my page 11. Issue a writ of mandamus or any other appropriate writs directing either the opposite party number 5 or 6 to take up the investigation of the ITR incident arising out of FI number so pending in the court of learned SDJM Baleshwar. Further direct the opposite party number 4 to hand over all the connected documents arising out of FI number so in the court of pertaining to ITR case at Chandipur, presently investigated by the crime branch to CBI NIA, because here we have made a prayer that the investigation
in 2021 September 21 this petition was filed.
And now already the charge sheet has been filed.
Now in the meantime charge sheet has been submitted.
Charge sheet has been filed. Now that prayer that has become infractuous for all purposes. And the second, you want the disclosure of some documents that the Section 8 of the Right to Information Act actually doesn't allow us to reveal this.
No. We do not want any of that.
You can track the trial. You can go from the certified copy or from the trial court with permission of the judge concerned. How can we can in the public interest litigation disclosure? Better we close the matter. We close the matter, give liberty. If you have the additional materials, you can approach the investigating officer. If from the materials it appears the further investigation is required, he will do the further investigation. Because mere filing of the charge sheet doesn't close the chance of filing of the investigation. Further investigation.
I am submitting that this consent is all right. Government of India is supporting, giving all cooperation to the state agency, investigating.
All right.
And they are extending all sort of cooperation to the state investigating concern that case has been filed, and we are submitting all the documents.
All right. So NIA was cooperating with them.
NIA has not come to picture because it is on the state.
No, from the behind the screen.
But thing is this, we are extending all sort of cooperation.
All right. Good.
May I just interrupt for a moment, my lord? Your lordship, kindly see the order dated 7th of December 21, my lord.
I have seen that December 21 order. I have seen.
What I'm trying to say, the earlier bench, my lord, had directed the Central Government Council to file an affidavit stating about the
Central Government Council expressing the satisfaction the way investigation has been done.
I understand.
Further nail to your prayer. So better we close the petition. We've given liberty that if any materials comes to your hand, you can approach the investigating officer. An investigating officer, after examining the materials, if it is required to further investigation, he will do it.
No, but as a common citizen, I cannot have any access to this foreign agency's documents, my lord. It is for the investigating agency to find out. How can I, as a common citizen?
And when the material is a part of the investigation, this Section 8 impliedly says that those documents should not be supposed on revealed under the right to information.
Correct.
So therefore,
No, my-
they are supposed to do this kind of a thing because there is an inherent danger in it. Because we do not know the document goes from which hands to another hand. All right. But
Can I make a simple submission, my lord? Now the charge
Yes.
sheet has been filed, so we don't have access to the charge sheet. So let the state government produce the charge sheet before your lordship, so that your lordship knows exactly.
charge sheet has
In
not
any
been
case, we
filed.
cannot.
Charge has been
In any
framed
case,
and
we
it is
cannot.
going on
Private
trial.
individual.
So there is, we are not interested, to be very honest. We are not
Because
interested.
this is a serious
Heard
issue.
Mr. Gautam Kumar Acharya and senior counsel appearing for the petitioner. By means of this petition, the petitioner has asked this court to direct the opposite party number 5 and 6, Union of India, opposite parties, to take up the investigation of the Chandipur PS case number 76 of 2021, which was registered on 14/9/2021. Stop. A further prayer has been made to hand over all the connected documents arising out of this said police case to the ITR case as Chandipur, presently investigating by the crime branch to CBI/NIA/SIT. Stop. By filing an affidavit, the investigating officer, Superintendent of Police, CID/CB, has categorically stated that this investigation, after completing the investigation, charge sheet was filed, leading to ST case number 62 of 2022. On framing the charge, learned additional district judge 3 Balasho has commenced the trial. A good number of 3 witnesses have already been summoned for recording their evidence. Stop. From the said affidavit, it appears that investigation is complete. At this stage, Mr. P.K. Parir, Deputy Solicitor General of India, appearing to the opposite party number 5 and 6, has submitted that investigation has been done with all earnestness and leading to filing of the charge sheet. The central agencies have cooperated with the investigating officer in the case number Chandipur PS case number 76 of 2021. Stop. In view of the above development that has taken place after filing of this petition, I think the purpose of filing the writ petition is over and it is useless to continue with this proceeding. Accordingly, this proceeding stands closed. However, if any evidentiary materials comes to the knowledge of the petitioner, he may place those materials to the Superintendent of Police, CID/CB. Stop. On examination of those materials, if it is found that there is a requirement of the further investigation, that will be so done by the SPCID/CB in accordance with law. Mr. Budhia, you are there in this matter. For whom?
In person.
Oh, all right. Mr. Budhia, Arun Kumar Budhia, learned petitioner, has appeared in person. All right. But for whom Mr. Acharya is there?
On behalf of me, Mr. Budhia,
On behalf of myself. So don't scroll out that line. Your submission has been made by Mr. Acharya. Okay.
Obliged.
Obliged.
17.
May I please the lordship? On last occasion, lordship directed me to file rejoinders. Our draft is already ready, my lordship. We will file by Monday. We'll file by Monday. Draft is already ready, but because of the posting of the petitions on different stations, they couldn't file, came before us for filing
11th of
affidavit.
September,
My lordship.
at the request of Mr. J. Biswal and counsel appearing to the petition, let the matter be listed on 11th of September 2023. In the meanwhile, you will file it.
Yes, your lordship. By Monday, we are filing.
In the meanwhile, you will be filing an additional affidavit or rejoinder.
Rejoinder, your lordship.
The meanwhile, the petition is invariably filed the rejoinder. No further accommodation will be made for this purpose. Mr. A. Behral and original standing counsel appears for the opposite parties. 18.
Much obliged.
May I please, your lordship?
Yes, Mr. Pari.
Lord, in the present appeal, Lord, I'm asked.
I'm seeking an adjournment on behalf of Mr. Rath, appearing for respondent number 6. Lordship may kindly adjourn it on Monday.
Not Monday, because I'm Monday and next week I'm absent. No, this, I'm just reading for your benefit. And by the order dated 26th June, this court passed an observation. On the next date, there shall be no accommodation. So if a counsel has taken a risk, let him take the risk. We proceed with the hearing of the matter. 26th June 2023.
And in the meantime, my lord, there has been some developments which my lord, renders it in a way, my lord, the proceeding, which would have rendered the proceeding before the honorable single judge infructuous. There has been certain orders passed by this honorable court in the meantime, which my lord, I am bringing by you a memo, my lord.
Also, Mr. Rathore.
Yes, yes. My learned senior was there in that case also. May I just please?
All right.
These were passed in the presence of the client for the my learned senior, my lord.
Are you free tomorrow?
My lord, I am always there. I have no difficulty, my lord.
So it's tomorrow.
Yes.
At the request of Mr. B. Rathore, senior counsel, appearing with Mr. Here, appearing with yes. Mr. Shekhar is not there today.
Mr. Shekhar is not there.
Mr. J. Biswal and counsel for the respondent number 1. You are appearing for the respondent number 1. You are appearing for the bank.
No, my lord. My learned senior is for us for 4 and 4. 4.
I am appearing the respondent 4. Yes. So let the matter be listed.
1, 2, 3.
Give only the date.
I am appealing for 1.
All right.
1,
2, 3. Bank. All right. So what is your good name? Mr. Sachin sir, appears for 1, 2, and 3.
1, 2, 3.
Respondents number 1, 2, 3. So it will come tomorrow.
Can you also keep it to Tuesday? Tomorrow I was thinking that I have.
No, that is why you are trying to arrest the counsels from going to Mafosil. Let their lawyers get some nectar of the profession. It will not take much time. Come for once.
Oblate.
Yes.
Number 19.
Just at Sachin sir's date, at the request of Sachin sir, yes, some new documents have been placed. That what we just after adjournment, some new documents have been placed. Yes.
May it please your lordship, my lord. My lord, the honorable single judge under annexure 4, keeping in view the technical consideration, though I have a substantial question and fair question to raise, without going to the merit on the ground of delay, my lord, dismiss the case. As such, the findings arrived at by the honorable single judge, and the very face of the record also is not sustainable. It is an error of record. My lord, the OLR proceeding was initiated 50 years back, 74, finalized also 76, almost 49 years back. Then I was found to be in surplus land. So 16 standard acres found to be surplus. I have been disposed to the extent of 16 standard acres. It vested in the state. And I am occupying 18 standard acre. 25 years after, it is reopened pursuant to the revisional order by the member board of revenue that I am again to surrender 2 standard acres. That will be 4 or 5 acres land. So I am in possession, and I have challenged that member board of revenue's order before the honorable single judge. And I am at Kalahandi 500 kilometers. It continued here. I don't know that such a proceeding has been closed, my lord. There is
You are not given notice?
My lord?
You are not given notice?
No, well, it's no notice. I did not know anything, my lord.
When the revision
Nah.
petition was taken up?
Mohan Panda is my father. Mohan Panda is father. The honorable single judge, my lord. Mohan Panda is father.
No, at the time of when the revision proceeding was taken up again, then whether you are given notice?
No, I have not received any notice. My client today, I also taken instruction. It is reflected that Jagdish Panda is notice, so and so notice. There is no notice, my lord. There is no notice. And the record speak for itself, no notice.
Have you approached this revision board?
My lord?
Have you approached the board?
No, I have not approached state.
No. When you will not, state is approached for further land.
For in revision.
That whether since you have discovered that you are not served notice,
yes,
have you approached the board that I have not received notice?
No, what happened, your lordship? When the proceeding, no, yes,
because at that point of time his father was early.
No, father,
single judge.
97 father expired. 2001, my lord, proceeding revisional court, the revision was.
What is the death certificate of
Yes,
father?
yes, exactly. What my learned friend is written.
No, you learned it on the basis of the learned single judge.
Yes,
I am just relying upon
obvious, all right.
Kindly
Show the
see
death certificate
page 31
of
31 of my brief, my lord. Writ appeal. Your lordship may kindly see that is annexure 3.
Yes.
Nowhere Mohan Panda's name is there.
No, I am when he died. Where is the death certificate?
He died in 97.
Your oral statement will not do. I want to see the death certificate.
No, what I beg to submit. That is your.
What do you beg to submit? It's a matter of document.
Your
oral statement doesn't have any value because nowadays death certificates are issued invariably.
No,
What is the death certificate?
No, I say 97. Say by now Mohan Panda must be 120 years like that. He died in 97. My lord.
120 years he died someone
By,
died
up to our till date. 97 he expired. 97 he expired. No.
My lord is asking whether you can
Yes, that. I bow down that a document is required.
No, otherwise, birth and death register, certified copy of the birth and death register will do. Because now you are under compulsion to report the death or birth to a registrar. It is maintained in a village level.
I would get the death.
See,
death
annexure
certificate.
3.
Huh.
Jagdish Panda himself was a party. This
But-
petitioner before your lordship.
No. That is why I asked him.
Serial number 5.
Jagdish Panda was a party. His case is that this proceeding started in 2001 and Jagdish Panda died in 1997.
Not Jagdish Panda. Jagdish Panda himself. My lord is appealing for Jagdish Panda. Appellant before your lordship is Jagdish
No,
Panda.
the finding is Mohan Panda, my father, participated in the proceeding. That finding suffers from error of record. Annexure 4, honorable single judge finding.
Where is the finding his name? Mr.
My lord,
Bharti?
page 31, post title, serial
Five,
number
serial number 5.
Paragraph 3.
No, sir. Page 31.
No, read also paragraph 3.
At page 32.
It is on page 32.
Since Mohan Panda, my father is dead, definitely I being the son, my lord, it is my name is reflected. That exactly I am saying. Before initiation of revision, Mohan Panda is no more there.
No, just see also paragraph 3 at page
Jagdish
32.
Panda was noticed. It is
No.
mentioned in the issued order.
No, that is record. I don't say. It is recorded, but I have not received any notice.
You have entered appearance through your advocate.
No.
That is also there. SK my advocate.
What I have said is,
For opposite part number 1 to 9, Mr. SK Swai advocate and Mr. VN Mahabatra advocate. You are opposite part number 5, Jagdish Panda, appellant hearing.
No, not that, not that. I have not received notice. The advocate is appearing from other clients, my lord. Your lordship may kindly see when the case was closed. That is my case. When the case was closed, I don't have any knowledge, my lord. It is closed, my lord, almost 7 to 8 years after. I am at a Kolahandi, my lord.
But the court records that Mr. S.K. Swine was appearing for the opposite parties number 1.
That is not 1 to 9. But Jagdish Panda, other brothers are there. Jagdish Panda, your lordship. I have said before, my lord, Jagdish Panda has not been represented. Jagdish Panda did not know when the case is closed. My father, Mohan Panda, it is the finding of the honorable single judge. My father, Mohan Panda, participated before the original court. The order is in my favor. I petitioned before the Tahsil.
This is the question. Let us see. Would request Mr. D.K. Mohanty, London Government Advocate, to request the Board of Revenue Orissa produce the records of OLR revision case number 13 of 2001 on the next date. Let the matter be listed on 25th of September 2020. 25th.
25th.
We are calling for the record.
Yes.
If I find that you have signed the Vakalat,
Yes, I will produce the
rest issued, the huge cost will be imposed on you.
My lord, may I will pray one thing, my lord. Status quo may be granted. Status quo may kindly be granted. Status quo. Other day at my instance, my lord, it was adjourned. So I did not pray. My lord, I have to be dispossessed. They are taking active steps.
If you any action for disposition take, you come back on the very date you will stay. Because there is no such move. Because they know. Mr. Mohanty just request.
I will just get the record and I may not be directed to file any affidavit. I will only produce the record.
Oh no, yes, only produce the record because we will check whether they have issued this Bhogalatnama or not. All right. Come on 25th of September.
Yes. 25th of
20. Yes.
That permitted me only 2 days time for the hearing because I am seriously engaged in this case. Seriously engaged in the case. The repetition is the file of repetition is now with me. Only 2 days.
No, we'll dismiss your petition.
Miller.
It will pass that the no accommodation will be made on the next date. On that condition, earlier occasion, we granted you the accommodation.
Miller.
So dismiss it again for non-prosecution. You are not interested to do the case? No. We restored the case.
Miller.
On that condition only that you will appear and make your submissions today. Since you are not doing, you are dismissing the case.
No, I am pressing.
You just make your submission.
The appeal
No, that was
challenging the dismissal order under annexion number 1.
Already restored and listed for hearing.
Well, before my friend starts your lordship may say there is a IA, your lordship may say there is an IA in that list to allow him at first. That IA
amendment.
No, there is an IA perhaps to engage a new, your lordship may see that there is a voting to engage a new council. Perhaps he is the new council.
Earlier, Mr. Panda was appearing.
Yes, my lord. So that IA may dispose of.
Okay.
That noting that
28 days delay also is
there is also delay that to that effect no petition has been filed.
That new council, so he doesn't know.
So for that reason I pointed out all this. You should have taken all these steps prior.
Certified copy not right.
There is no application also for the
Yes,
coordination
madam.
of the delay.
For corners, no application.
There is a file, my lord, the mistake number 6041 of 2023. It is not in record, my lord.
Just find out from the 6041 one.
6041 for condonation of delay.
Condonation.
देखिले सिस्टम रे फाइल भी देखिले सिस्टम रे नोटिस when did you file Mr. You're Mr. Samal? Today you filed?
Today I have solved the copy. Today
Perhaps, not perhaps. You tell us when you filed.
Today or filed.
Everything there. Everything that's it. System रे देखियो देखो number you must have got a number also.
That is 6041.
6041.
Few days delay.
28 days.
28 days.
You condone the delay, it is right.
I'm not getting the application.
Application number दियंतु.
Is not on record.
He's filed today.
All right, bring the record.
He told in the morning we could have got it.
Bring the record, send someone to bring the record.
Phone करो. Special notice, where is Mr.
You just wait, we are bringing the record.
No.
Just give the record. Just wait for some time. You record, we are bringing the record. Application is not in record. We are bringing it. Where is Mr. Dayananda Mahapatra who mentioned the matter?
He has mentioned the item.
All right. Where is he?
Phone करो.
I called him right now.
My lords, Mr. Mahapatra is on his legs. He'll be arriving shortly, my lord. He was in another court.
All right. Where is Mr. Raut?
Oh my God.
Mr. Who is appearing? D.K. Mohanty or Mr. Kuntia?
In
This
Mr. Mahapatra's case, I am appearing for in that case.
Come to the page 42.
My lord is holding the brief 28234. 28234.
28234.
Yes, page 42.
This is a photograph.
Photograph, there is colored photograph. I have to take instruction what is the matter going on there.
No instruction, we are passing order. Instruction, just I think you are following the Jadavpur incident.
My lord, actually,
For a lapse of 1 hour, one student committed suicide in the hostel itself. Failing to tolerate and bear this torture in the name of the ragging, they were just pounding on him.
I leave it to your lordship, whatever audible, but what has happened today, it is not in the list. Had it been in the list, I would have obtained instruction in the first hour. Anyway, if your lordship thinks that it is a serious matter, it is actually a serious matter.
What is that? This things with them? These messages. It's all.
Messages on the phone, pushing them because first year one group has been created.
Moreover, ranking has been banned nowadays. How these things are going on?
You are Mr. Raut?
Yes, my lord.
I think they have a committee also, anti-ragging committee.
There is a
also
committee,
there.
anti-ragging committee in all the.
So what they're doing, turning a blind eye, deaf ear? 27/6 since June, these letters have gone.
That's representation. Annexure 2.
To the chief secretary.
Yes, ma'am.
They'll be termed as mother and father and harass the child and students. Instead of taking care, they harass. That has been sent then. Another one.
But Mr. S.K. Raut, Learning Council appearing to the petition and no.
Oh.
Stop. By means of this public interest litigation, the petitioner, who is a public spirited individuals, has brought to our knowledge the physical and mental harassment meted out to the students of the to students who have been freshly admitted in the Maharaja Krishna Chandra Gajapati Medical College at Behrampur by the senior students. According to the petitioner, the incidents of ragging in the form of physical and mental torture were brought to the notices of the respondents from the various quarters. Stop. In support of this contention, some WhatsApp messages copies of some WhatsApp messages and photographs have been furnished with this petition. Stop. There had been in the past a concerted effort by prohibiting these kind of activities and in-house committees to stop the ragging and other mechanisms were adopted. Stop. We are really shocked that despite the notification dated 3/8/2009 issued by the Medical Council of India, the medical colleges, a few medical colleges are failing to arrest this kind of activities within the campus and hostels in particular. By the said notification, which was issued in tune with the guidelines earlier issued by the University Grants Commission. the ragging has become made punishable. And certain measures for prohibition of ragging has been provided. Since the said notification is issued by the Medical Council of India, that is binding on the said medical college, prima facie we are satisfied. The college authorities are failing to discharge their duty from extending protection to the students freshly admitted in the medical course in that college. Stop. We are greatly shocked. Stop. Issue notice to the respondents returnable on 11th of September 2023. In the meanwhile, we direct
Superintendent MPC.
Superintendent of Police, opposite party number 6.
My lord, Superintendent of Police. MKCG, Superintendent of the hospital. Yes.
No, Superintendent, not hospital, it is a college. Superintendent of
you will
Police,
contact
Beharimpur District, Ganjam, to have immediate consultation with the Dean and Principal, MKCJ Medical College, Beharimpur District, Ganjam, and take a stock of the situation. The opposite party number 8. And after such consultation, to take drastic action against those senior students who will be found indulging in such immoral and unacceptable conduct despite the prohibition by the Medical Council of India. We also direct the opposite party number 8 to take immediate actions to segregate the students freshly admitted from the senior students by completely stopping their access to those fresh students. Stop. A copy of this order is supplied to Mr. D.K. Mohanty.
Today you have lost. Tomorrow I will.
Forthwith by 2 p.m.
Yes.
Stop. Also, a copy be supplied to Mr. Raut, Current Counsel appearing to the petitioner. Mr. Raut, you take steps for service of notice.
Yes,
all
madam.
Just all are government respondents.
No, one of them has to be notified, I think.
National Medical
National
Commission.
Medical Council, opposite pattern.
So Mr. D.K. Mohanty accept notice. And this is a government medical college, I think.
Yes, yes.
For opposite parties number 1 to 8, and hence no formal notice is called for. However, the petitioner shall take steps for service of notice on the opposite party number 9 by speed post to 8 AD in the course of the day. Yes, who has given? This just after the medical council guideline, we just add something more. We may also note that the Government of Orissa Higher Education Department issued a notification on 3/8/2020 regarding suggesting ragging prevention measures in universities and colleges. Stuff. For arresting the dehumanizing and abominable acts of a very minuscule section of the students. Stop. And that notification was issued to eliminate the scourge of ragging from the higher educational institute in the state of Orissa. Stop. in this, by the said notification, the anti-ragging committees at various levels were supposed to be set up to check the anti-ragging, to check the ragging by initiating effective measures.
Yes.
In this thing. We have passed the order, Mr. Mahapatra.
Minutes. Oblige, minutes. I was keeping in another case, man. Sorry, minutes. I beg excuse, man.
It's all right, it will come again on 11th of September.
Putting it minutes and
11.
11th
of
September.
must have seen that photograph minutes.
That is the basis of our
Photograph minutes. Not only that one. Thereafter, after filing this, once
File additional materials.
I mean, it's still continuing. Still continuing.
must continue in a very rigorous manner. But the students are suppressed in such a way.
Now we
they
have
are unable to
given to the main direction. SP will meet the principal, dean and principal of the college, and they will discuss the issue. They will find out the culprits and immediately take action against them and ask this principal to
Right.
segregate the first year students from the senior students in order to protect them from this kind
Yes,
of
ma'am.
activities.
not only
the predicament is here. The culprits are also students.
No, that
No,
they are-
must
they
have
are
that-
not
that
students.
will
They
not
cannot get
absolve
the
them from-
protection of students.
Uh,
not
this,
that manners, may I submit manners?
criminal life.
Very important aspect manners. Throughout Odisha, all universities and colleges, we don't have a student union to avoid all these contingencies.
No, you
But
don't
these
divert
medical
your
colleges,
case to
they
that.
have a student union and every year they do have a representative. Manners, that
Class
is what these
representative.
things are happening in the way.
But the students are very happy without the union.
Manners,
Students are also very happy without the union.
that is correct, but fact remains matters in this case, not only student of first year, but kindly see the hierarchy. They say it is a culture. First year student would be ranked by second
No,
year.
no.
That we know.
Ragging that is different, not of this nature.
Any sort of ragging, we are against it.
Yes, yes, ma'am.
Because whenever it is a personal choice and other thing, they just come to curb it. Nobody has given the authority of the guardianship.
Manners.
In a family, what we enjoy. These people are taking not only the high-handed approach, but they are doing certain other things which cannot be said in the open court also.
Manners, exact.
Are all young boys, brilliant students. They got medical.
Everything they can do, but the ragging has been defined by the Medical Council of India. That is, we have referred to the particular notification. And all the colleges has been just warned, if this happens, even they can cancel the affiliation of the college.
Yes,
To that
sir. Yes,
extent, the
yes,
notification
yes.
has been given.
Very serious thing.
Yes, where is Mr.
Item number 20.
20. 20%.
Appellant असेल.
You are Mr. Mazi.
Yes.
Heard Mr. Mazi Lamit. Council appearing for the appellant applicant. This I number 6041 of 2023. This is an application for condoning the delay of
28 days.
28 days in filing the intercourt appeal. From the order dated 6th of May 2022, passed by the learned single judge in WPC number 6479/2015. Stop. There is a delay of 22 days, 28 days as stated. Stop. Mr. D.K. Mohanty, London Additional Government Advocate, appearing for the opposite parties, has stated that the opposite party will not resist the prayer for condonation of delay. You are appearing?
Yes, ma'am.
Mr. M.K. Kuntiya. Stop. We have also perused the causes to explain the delay. Stop. As the opposite parties have not opposed the prayer, we condone the delay. In the result, this application stands allowed and disposed of. Are you making a submission in appeal?
No.
Are you ready today?
Yes, I have gone through that. I will take instance. He has filed an affidavit. You can find it from 16(8). As it appears from that affidavit, a similarly situated persons have been given appointment with effect from 2011. If that is so, I will take instruction on that point. He can get also justice.
Let come tomorrow.
Monday.
Come prepared to Monday.
No, my lord. Some more.
Don't
time.
regular days you go. We have no space actually to accommodate. That is tomorrow. There will be some spaces.
You'll also fix it to tomorrow. So if I will take,
Alright.
I will
If
come
you
with
find
that instruction.
difficulty,
It can be
let him
disposed of.
take let the matter be listed. I think we listed again tomorrow for consideration. You also, Mr. Mazhi, that you remove the defects. There are a lot of defects.
Yes, my lot of defects. Let him
In the
do
course of the day, appellant shall remove the defects identified by the registry in the course of the day. You go and remove the defects. All right, so single H is at 2.
Today's single bench supplementary list, page 1, item number 1 to 7. Page 2, item number 8 to 17. Page 3, item number 18 to 24.
My lord, item 22, my lord. Item 22 is, so partner, I have taken consent from my learned senior. Let it be next week, my lord.
Is it 2018 matter?
I have some personal difficulties, my lord. Next Friday, my lord.
Based on in the date on next Friday. 8th of September 2023. At the request of Mr. K. Guru, Learned Counsel, the petition.
In item number 23, now I filed my Oklahoma on behalf of opposite party. That means that not after police.
File the Bhagavatam in the registry. 23, item 23. Oh yeah, I'm not granting this. It will come in the next week.
My lord, find this previous product. I look in your case. But when this case has been listed, instead of my name has mentioned the name of opposite party. Party's name, my lord. So this case has been.
That will correct. There is no difficulty in that.
Taking the rest of my lord.
You are appearing for the petitioner.
I am opposite party, my lord. I am for the. My lord, my friend is filing Oklahoma today for opposite party.
All right, that will come out in the next Friday. No, we'll not grant you to. It is a 2018 matter. There is a limit to everything. is a 5 years for a reference matter. Let this matter be listed on next 8th September 2023 at the request of your good name. Your name, Mr. A.K. Behera, learned counsel, who has entered in the appearance for the opposite parties. Mr. Behera shall file the power in the meanwhile.
For the petitioners, I am appearing in the CLPL with the consent. But in the arbitration matter, Mr. Yusuf Panda is there. But he has given consent, 9 MB reflected.
Here we filed the Vakalatnama.
In the CLPL, I have filed.
So, all right, Mr. D.K. Sahul and counsel appears for the petition. All right.
Okay.
No
Item
further
25
reference will be
minutes.
made in this matter on the next stage.
That's item 25.
The next stage. Yes, next.
Mr. Item 25, it was adjourned because a similar SLP is pending before the Supreme Court. On that ground, it was being adjourned. That is still pending. Item number 25. Yesterday only I've taken, I've checked it, and it is still pending. That similar issue is here also. In that matter, the arbitrator was appointed. The Honorable Supreme Court has stayed the arbitration proceeding.
Why?
Because they are in the Honorable Supreme Court, the MCL went in appeal, and MCL the contention was that there is no arbitration agreement
clause.
I'm same to mine. The clause is similar to mine also.
In this case, there is any arbitration clause or not?
There's an arbitration clause, but it is specifically that the ground that have taken the High Court stay that have been granted by the Supreme Court.
Already here you wait there.
Yes, all
right.
Pardon, my lord.
Yes.
Page number 1, item number 4, your lordship.
It is over now. Wait for some few minutes. Yes. All called out.
Page 4, item number 25 to 31.
Item 20, not not filling over any other.
At the request of Mr. U.C. Behera and the counsel appearing for the petition at the 8th of September.
Page 5, item number 32 to 40. Page 6, item number 41 to 50. Page 1, item number 1.
Arbitration proceeding. Report on 28/4/2022. I have filed the restitution application within time.
My lord, I am filing my wakalat number today, my lord.
Any objection regarding restoration?
No, my lord.
All right. What is the order by which it was dismissed?
Order dated 28 October 2022.
Have you not annexed with the petition copy of the order? You have not attached.
Not annexed.
It has to be filed. All right, let me see.
I have a printout. Okay.
This order was passed in IA number 21 of 2022. What was the IA?
IA filed for revival of the proceeding, but initially on 14.
IA 21 of 22. This is a part of the arbitration petition number 59 of 2017. What is the IA for?
IA for revival of the order number 15. 4th January 2019, is allowed disposed of the arbitration petition.
Oh, this is the second time dismissal.
That disposal on ground that the matter is under settlement between the parties and amicable and liberty granted to both the parties. If the settlement failed, then they can have liberty to file application for revival. That is the order. In view of the above, this ARBP is disposed of. However, liberty to granted to the party to
My lord, I will file objection. In that I will file objection, my lord.
You have filed the objection.
Yes, my lord.
All right, that will, only the IA will be restored, not the, only the IA, yes. Heard Mr. N.K. Saul and the council. You are Miss Patnaik,
Yes, my lord. My Vaklatnama may be.
your name is already there, already filed the Bhogalatna.
Yes.
And council appearing to the applicant. This is in miscellaneous application number CM appeal number 70. Appearing for the applicant and also heard MSS Patnaik and counsel appearing for the opposite parties. So, by means of this petition, the petitioner has held this court to recall the order dated 28/10/2022 by which the IA number 21 of 2022 was dismissed for non-prosecution. So, Mr. Saul and the counsel has submitted that non-appearance at the time when the matter was called out was totally unintentional. So, be that as it may, as Ms. Patnaik and counsel has clearly stated that the opposite party will not oppose this petition for restoration. The order dated 4/1/2019, passed in IA number 21 of 2022 is recalled, restoring the IA number, said IA number 21 of 2022 to its original file. Now go back to that. Yes. What is your submission regarding this revival? Why are you opposing it?
My lord.
This 21, I have taken up this for the revival application.
Yes, my lord. In that, I will file my objection, my lord.
You have not filed the objection?
No, no.
2021, Ms. S.S. Patnaik and counsel appearing to the opposite parties, praised for accommodation for filing the objection. That the matter be listed on 8th of September.
No, my lord, let it on 15th, my lord.
All right. Then maybe on
8th
15th of
out.
September 2023. Meanwhile, the objection, if any, shall be filed by the opposite parties.
So,
May I please, madam?
My lord, pardon to make a mention, my lord, in BP number 1 of 2023, we had filed the IA for modification, IA number 7 of 2023. In that, my lord had been pleased to pass an order on 4th August 2023. In the order, my lord had directed for a copy of the corrected order to be supplied to the council, but the corrected order has not been supplied and is not yet available either on the website.
Is not also in the website?
No, my lord, the order dated 4th August is there on the website, but the corrected order is not there.
Just check up this corrected order. Give me the file, whether it is first check up in the whether that is in file or not. Give me the physical file. When the corrected order is there, first check up. Physical copy files are not here. We'll check up. We are fixing order 8th of August. But if it is not uploaded, we'll look into this. It uploaded, we again fixing the matter on 8th of August. So yeah, September, August is over now. Listed 8th of August. It isn't stated.
My lord, this small request, if it could, my lord, could take up the matter before that, if I could be allowed to mention, because the letter, the arbitrator tribunal cannot be formed till the letter, the corrected copy of the order is given to the arbitrator.
That will be checking up today itself, bring the problem. So bring the physical file. Ask them to, just today itself it will be uploaded.
Okay.
May I please, my lord? The application under section 11(6) of arbitration and
Have you
conciliation act
recorded the case
for
number?
appointment of
Which case she mentioned? This is not on list today? How will do this? No other is required. Just what you said. Yes.
is the application.
Yes, Mr. Patnaik, what is the matter? Yes.
Application for appointment of arbitrator under section 11(6) of arbitration and conciliation act.
A fresh petition.
My lord, the agreement is in vernacular, my lord. If your lordship will, that has been reflected also in notice, my lord, in vernacular.
First come to the annexure 1, where is the arbitration clause?
That is 12, page 24. Page 24 last. That is, I am in English. That is in Orissa.
Read.
That is, it is agreed if any difference regarding the construction of the building, that will be decided by a third party arbitrator, and the decision of the said arbitrator will abide by both the parties. There is a clause.
Notice.
Notice, my lord, annexure 11, my lord, 75 to 80, page 80. That is also in 79, that is the last part, in para 18.
All right.
It is in 18, that clause 12 of the development agreement.
Heard, Mr.
Para 18 of the agreement, my lord, notice.
You are SK or PK Patnaik?
Yes, my lord, I am PK Patnaik.
PK Patnaik.
PK Patnaik.
PK Patnaik, Planet. Counsel appearing for the petitioner, issue notice returnable on 15/9/2023. Steps for service from the opposite party be taken within 3 working days by registered post to AD. So take it, if 15th is the next date. Next. Next matter, you call next matter. Call the next matter.
Item number 3.
May I please, my lords? Yeah, it's a fresh section 11 application.
Yes.
The arbitration clause, my lords, would find at page 20. Clause number 16. Between the petitioner and Orissa Mining Corporation. And the 21 notice sent by us, that would be at annexure 10 series at page 94.
All right, heard, Mr. You are not on record, Mr.
My appearance memo has already been handed
Filed.
over today.
Okay.
Today itself I have given.
So Mr. Lance, senior counsel, who is assisting you?
With Mr. A. Sadhangi, last name in the causes.
A7.
A. Sadhangi.
A7B Land Council. This is an application under section 11(6) of the Arbitration and Conciliation Act 1996. Issue notice. Returnable on 15th September. This step for service of notice and the opposite party be taken within 3 working days from today by registered post to AD.
I have a small request, my lords. Item 20 is also similar to this. It has been listed under the heading of orders for defect. Defect is page numbers are not legible, that will all rectify.
That you undertake within by Monday, you will do
By
it.
Monday we'll do it.
All right.
Item 20 is same parties, everything is same.
Is a fresh matter also?
Fresh. ARBP 47 at serial number 20 in today's list.
Say, Mr. Sarangi is also there.
Same, everything is.
Same order, only last line it says. The Mr. Sarangi, learned counsel to the petitioner shall remove the defects by 4th of September 2023.
By 4th we will do it.
All right.
We are all great.
Fourth,
Item number 4, Your Lordship. This matter is laid by my learned senior advocate, Ms. Pamidat. Lordship, she is out of station today.
What for this matter?
Your Lordship, this is a matter about extension of time for arbitrary award.
Is it petition by arbitrator or petition by the party?
Lordship, by the party as well as the arbitrator has passed an order that is in annexure 5 series, Your Lordship, page 21.
With the arbitration, right?
An appropriate application for extension of time under section 29A of Arbitration and Conciliation Act 1996 shall be filed before the Honorable High Court.
By whom? By the parties?
By the parties, by the both the parties.
All right.
In the meantime, Your Lordship, the pleadings has already been completed as well as one part of hearing has also been completed. After that, the learned arbitrator has
I hope this is not an international arbitration.
no, Your Lordship.
All right. What is your good name?
Lordship, Sucheta Guman Singh.
Hard such and such, Sucheta Mansingh. Stop. It appears that arbitrator could not pass the award within the time stipulated by this court. By its order dated 19/3/2021 in ARB number 20 of 2020. This court within the time limit by this court, in view of the order passed, just recast, order passed on 19/3/2021 in ARB number 20 of 2020. The arbitrator could not pass the award within the time as provided under section 29A of the Arbitration and Conciliation Act. Stop. Here is the application for extension of time for issue notice returnable on the same 15/9. Are you appearing for the opposite party?
No, he's with me.
So notice, issue notice, steps to be taken for service of notice on the opposite party within 3 working days from today. Notice is made returnable on 15th September 2023. Next. So you take steps within 3 days.
Okay. Obliged, Lordship.
5. Item number 5.
May I please, Your Lordship?
None
Lordship, sincerest apology, I'm unable to appear in court.
2023. No further
Lordship.
recommendations be made on the next stage. Next.
6.
May I please, Your Worship?
Yes.
My lord, the petitioner performed as per the contract agreement under Annex 1, dispute arose between the parties for which the petitioner demanded for arbitration.
What happened? Just a minute, 1 second. Yes, call. Yes.
Item number
Lordship, Lordship, sincerest apology, Lordship, there was
Who is
some error with my
appearing by the virtual mode must immediately knock the court.
Yes,
Because
Lordship, there
this is
was,
your duty. You must open your screen before the matter is called out. Okay.
Lordship, there was some error. Sincerest apology, Lordship.
What
Lordship,
happened?
Instant matter. Lordship, this instant matter pertains to appointment of an arbitrator. Lordship, the clause would be at page
Where is
25.
where is the arbitration clause?
Lordship, at page 25.
What is the clause?
Lordship, it states that that memorandum of understanding will be subjected to the conditions of
What is the
arbitration.
clause number?
Lordship, 6, page 25, clause number 6.
I am not getting it. Just please mention properly. I think there is something is wrong. Page 25, I am not finding any. This is.
Lordship, page 25 of the petition, Lordship, that would be the MOU third page, Lordship, that is page 25.
You read
Lordship,
that the line.
Yes.
First line.
Yes, the arbitration clause, it states that if any disputes arising out of and concerning the interpretation of this memorandum of understanding shall be subjected to the jurisdiction of a joint arbitrator to be appointed by the both parties and their decision on the matter.
Is 5, no? Just wait. And your demand?
Yes, Lordship, like in this MOU, it was accepted by the opposite party that a credit balance of 28 lakh was supposed to be paid by them, which they were supposed to pay within 90 days. And if there's any kind of event where they are unable to pay it, there is an extension of another 90 days.
You are Mr. SUBHASIS, I think.
No, Lordship, TR Sen, Lordship.
Heard Mr. T.R. Sen, Learned Counsel appearing for the petitioner. This is a petition for appointing the arbitrator. Stop issue notice. The returnable on 15th September 2023. Steps for service of notice on the opposite party shall be taken by registered post with AD within 3 working days.
Okay, Lord.
Next. 6.
May I please, Your Worship? My lord, since the dispute arose between the parties, the present petitioner approached the opposite party.
You just show me the arbitration clause first.
My lord, arbitration clause is found at 48 of my lord's page 48 under clause 45.1, where the arbitration clause is existed regarding appointment of arbitrator. Under clause 45.1 or page 48 of my lord's
Page.
Page 48. My lord.
All right. And your notice. Your notice. This is Annex 6. Annex 6 is your notice.
My lord.
Heard Mr. N. Johar Singh, current counsel appearing for the petitioner. In the agreement, there exists arbitration cause for resolution of the dispute by sole arbitrator by the notice dated 17/5/2023. Petitioner demanded the appointment of the sole arbitrator and proposed a panel of arbitrators for such appointment, but the opposite party did not respond. Issue notice returnable on the same day. It will come on, take steps within 3 days. It will come on 15th September.
Complex.
Same order. Huh? Yes, next.
7.
Item 7, your lordship, is for the appointment of arbitrator. Yeah, at page 20, your lordship, clause 7 is the arbitration clause.
And you notice?
Notice, your lordship, is at annexure to page 22.
And what about the page 30?
Pardon, your lordship.
Is a reply to the notice.
The reply to the notice, your lordship, is in annexure 5, your lordship, page 30.
They are replied.
They have replied.
What is their reply?
The reply is, your lordship, that they are still willing to complete the work despite of and your lordship, that the dispute is premature.
Heard, Mr. V. Bhaiya. You are Mr. S.S. Bhaiya.
Yes, sir.
S.S. Bhaiya and a counsel appearing to the petition. Notice and terms of the arbitration clause was given, but the opposite party did not agree. There exists any dispute as they are still willing to execute the work assigned by the said agreement. So we should notice why the sole arbitrator shall not be appointed for adjudicating the dispute as laid down in the notice dated 13/7, I think. Your notice 13/7/2023 and except 2. Notice is made returnable 15/9. Steps for service of notice on the opposite parties shall be taken within 3 working days from today by registered post with AD. Next. Call the next matter.
8.
Item 8, your lordship. Similarly, the arbitration clause is at page 20.
The same thing, no?
Same thing.
Notice also same date, 13/7.
Yes, your lordship.
Similar, replicate same date.
The petitions are different, your lordship.
No, that is why. That is why petition's name will be typed. Alright, because relevant date is the date of your notice, and arbitration clause is same.
Yes, your lordship.
All right. And what is their reply in this case?
Similar reply.
That is premature.
Premature.
Okay. Next.
9.
Clause 9, I mean, was contractor and executed an agreement. Pursuant to the agreement, certain disputes arose. The arbitration clause is at running page 52 of the petition. Clause 14.
52.
52.
Have you done this mutual?
Yes, my lord. That's
Consultation.
that's at page 216, my lord. It's annexure 2. I tried, they did not reply to that. Then I issued the notice.
All right. And it is also the notice.
No, the notice is in page 220 because by then the disputes has not arose.
Okay.
I mentioned that for amicable settlement, as the
All
amicable
right.
settlement
Right,
failed,
right,
the disputes were raised.
Okay. You are Mr.
Siddhant Dwivedi, my lords.
Lord Mr. Siddhant Dwivedi, Land Council appealing for the petitioner. There is the arbitration clause in the agreement dated 27/10/2022. But such clause can only be provoked after the mutual efforts for settle the dispute through consultation. From the annexure, from the communication dated 1/11/2022, annexure 2 to the petition, it appears such consultation did not bring any positive result. Consequently, notice was issued on 10/1/2023, annexure 3 to the petition. So, issue notice returnable on 15th September.
Much obliged, Mr.
Take steps for service of notice on the opposite party shall be taken within
No,
3
the
work.
government is the opposite.
Your
but they
lordship
can
may say I
accept
am accepting notice.
They can accept.
Mr. A. Behral and Council appears for the Water Resource Department, the sole opposite party, and accept notice. Meanwhile, the objection, if any, shall be filed.
Good.
Next.
10.
Your
Your lordship is
lords
fixing it.
are same. A similar matter,
Same.
similar issue and similar.
Your lordship is fixing it.
Similar process followed.
Yes.
Dates are also similar.
Yes.
All right.
Your lordship is fixing it too.
15th September.
15th.
Much obliged.
Next.
12.
May it please respond. File an application under section 29A, taking extension of time for completion of proceeding. May kindly come to page 89 of my petition. They read out the relevant.
Any order passed by the arbitrator regarding non-passing of the award? Arbitrator passed any order?
Yes, my lord. Page 89 of my application.
So, heard Mr. V. Mahapatra and counsel appearing for the petitioner.
My lord, I have already served on the.
I am for the opposite party, my lord. I am for the opposite party, no objection.
And its senior is appearing.
Any objection for reference?
No, my lord. No, my lord.
All right.
At the verge
Extension, sorry,
at the
extension.
verge of completion, my lord.
All right,
So the final status, if they are not objecting, my lord.
all right. Heard Mr. B.M. Mahapatra and counsel appearing for the petitioner. This is a petition for extension of time for passing the arbitral award. As the arbitration award could not be passed when the same was referred to the arbitrator by the order dated 29/11/2019 in ARBP number 01 of 2019. Stop. Where is that order you have mentioned? Arbitrator's award, arbitrator's order?
Page
89, page 89.
It appears from the order dated 11/8/2023, passed by the arbitral, that to pass the award, the arbitrator requires further extension of time. Stop. So it will be the maximum time, that is 6 months and then 3 months.
My lord. My lord, 3 months, the mutual under 29(3).
Ah.
Under 29(5) for which the court can only grant.
All right. 29/5 says how many days? Is a discretion of the court?
It is
No.
there. Once 29(4) will be the relevant court provision, then
Yes. There is no allegation against the arbitrator?
No, my lord.
No, my lord.
So there is no stipulation regarding the time.
No, ma'am. It's at the final stage of cross-examination of the last remaining witness.
But I think I will grant only 60 days. Come to the section 9, subsection 9. It says 60 days.
My lord.
Mr. DP Tripathi, Learned Counsel.
BS Tripathi.
Yes, but what is it? Just read about the DP report.
Only 60 days.
Further extension, right? On the basis of the said observation, this application has been made. Mr. B.S. Tripathi, Learned Counsel, has appeared for the opposite parties, and he has stated that there is no fault in delay of the arbitrator, and as such, the extension may be granted. The opposite party doesn't have any opposition to such extension. Keeping in view of subsection 9 of section 29A, the extension is granted.
29(9) deals with the time period for disposal of the present application under 29A, seeking extension of time.
I'm granting this. I'm saying following the principle of the 5. 60 another date I'm granting to you.
Let's give 3 months because
All right.
some time may be required.
Having regard to these circumstances, as revealed from the application, an extension for a period of 90 days is provided for passing the award. There shall not be further extension. A copy of this order be supplied to be sent to the sole arbitrator through Mr. D. Mahapatra, Learned Counsel appearing to the petition. All right. Mr. Mahapatra will place the order you have directed to the arbitrator. Yes. Huh? How it is disposed of? The application stands disposed of. Yes.
13.
There's an application for extension of time for the arbitration, my lord. Consent proceedings. What is that? Appearing for the
Why? Who is you are appearing for the opposite party? This is a petition under section 29A of the Arbitration Conciliation Act for extension of time for passing the arbitral award. So, it is 14. Item number. Item number. What event is happening? What is the application for? Just can you hand over this application for, because some problem is there in the machine.
Pardon, my lord, application for?
Application for extension of time. Do you have a copy? It has not been registered. How that can be taken up? How this matter has been listed? If you have not filed it?
The order, my lord, arbitration order.
No, how this matter has been listed?
It was under
If you have
29,
not filed the
29A,
application.
my lord, so it's the application that said 27A.
No, this
Inadvertent-
extension application.
Yes, my lord, inadvertently that's 27A, it had to be had 29A.
I'm not getting you. You have not filed the application in the registry?
Yes, my lord.
For extension?
Yes, my lord.
What is that application?
IA 13 of 13, IA 13 of 23. 2020.
IA number 15.
13.
But this file is not opening. Call someone from the computer section.
There's been a noting, my lord. There.
Just 1 minute. Files are not opening. Files are not opening. Just check up the matter. All right, it's opened. Now opened. What happened? Yes. This is I number 13 of 2023. You are Mr. Bibhu Prasad Das.
No, Amitabh Naik. Amitabh Naik. A Naik.
Heard Mr. A. Naik on counsel appearing for the petitioner. The applicant. This is an application under section 29A. For 25A within bracket 5 of the Arbitration and Conciliation Act for extension of time for passing the arbitral award, which could not be passed within the stipulated time. Stop. You are Mr.
S. Patnaik.
S. Patnaik. Mr. S. Patnaik, learned counsel appearing for the opposite party, has submitted that the opposite party doesn't have any opposition if the time is extended for passing the award. Stop. In view of the above consensus between the parties, we allow the 3 months time to complete for passing the arbitral award following the procedure, but it is made absolutely clear no further time will be provided by this court for the same purpose. In terms of the above, this application is allowed and disposed of. A
Obliged, my
copy
lord.
of this order be placed before the arbitrator through Mr. A. Naik, Learned Counsel. You are Mr. Naik.
My lord.
Appearing for the petition. You just file a order. Next.
14,
Obliged, my lord.
item number 14.
Number 15.
Okay.
Next.
Mr. Saurabh Shekhar Behera in person. None appears when the matter is called out. That the matter be listed on 8th of September. If on that day there is no representation.
Yes, my lord, I am available. My lord, I am available. Saurabh Shekhar Behera, party in person.
Yes. Make your
Yeah,
submission.
yes. Yeah. Actually, my call list of ARDB 79 is scheduled on 11 a.m. on
You are
2nd
not
of December
audible. You are not audible. You are not visible also.
I'm not audible. I'm not visible. I'm visible
No,
now,
because
sir.
your
I'm
words
on
are not
virtual
audible.
mode. I am on virtual mode.
No, but using an apparatus which is not fit for this system. You change the apparatus.
I'm not audible.
No, you
I am
appear
not
on 8th.
audible.
You appear on 8th of September. I'm fixing the matter on 8th of September. Or otherwise,
Okay,
you
my lord.
use the good apparatus. List the matter again on 8th of September at the request of the petitioner in person. Today, the petitioner has appeared, but is by virtual mode, but he is not audible. So, next.
15. 15, my lord, may I please, your lordship. But your lordship, may 1 second. May kindly turn to the order dated 3rd of February 2023, my lord. Order number 4.
Yes.
Paragraph 5 at 6 and 7. The arbitration clause in question envisages a 3-member arbitral tribunal. Mr. Acharya informs the court that the petitioners have nominated Mr. Adis C. Agarwal, senior advocate, as their arbitrator. The opposite parties will now nominate their arbitrator positively on or before 31st of March 2023 and inform the petitioners of such appointment. The two nominee arbitrators will then meet and appoint the third arbitrator not later than 30th of April 2023. If there is any failure to comply with the above directions, it will be open to the opposite parties to apply to this court for further directions. Notwithstanding opportunity being granted to them on 3 occasions, they did not. So therefore, this the Honorable Chief Justice passed this order. So now that Millard, I don't know what is his instruction, but nobody has been appointed so far. 30th April is gone and 31st August is gone, Millard. 4 months have passed. So there is
What happened, Mr.
In this case, they served the IA on 25th August to search for instruction. Can you let's say be fixed to 2 weeks after?
No, 2 weeks after, it's already Millard delayed.
No, it is fixing on 8th of September. You take instruction because it is a simple issue. Either you will defy, other court will step.
Yes.
That we don't want, but if you cannot do, court has to. At the request of Mr. P.K. Paul and the Solicitor General of India, who is appearing for the opposite parties.
With SS Tripathi. With SS Tripathi, assisted by SS Tripathi.
He is running the show for your behalf for long time.
They should. We are already backdoor place. They should come up.
In the meanwhile, Mr. Pari, Deputy Solicitor General, shall obtain the instructions regarding appointment of the arbitral tribunal comprised of 3 members. In the event of failure, this court will step in for passing the appropriate order. Mr. P. Acharya, the senior counsel, assisted by Mr. S.S. Tripathi, has appeared for the petition.
One more prayer. Basically, this I have filed for 2 purposes. One is, Millard, there are 4 agreements arising out of the same transaction, WIS.
So they let one composite tribunal be same tribunal go into all the four agreements, because otherwise
Let me get instruction first. There are
no, that's it is I have prayed that Mila.
All
In
right.
para 3.7.34, that is the prayer. In the prayer also, that is the prayer. So, but it is referred to one agreement only, but all are identical agreements.
Where have you mentioned so?
7.34 Mila. It is pertinent to mention that all these said Mila, page 22 of the brief. Agreements being WIS agreement dated 29th March 2006, revised on 21st March 2007. WIS agreement dated
All right, Mr.
26th
Parikh,
April,
this
revised on
council shall also
all they mentioned.
take
So I have
instruction
prayed also for a composite
whether
tribunal.
the dispute arising out different four agreements as referred in the petition can be taken by the same arbitral tribunal or not, or whether they will agree that the dispute in such instance
Otherwise
will be taken by the same arbitral tribunal.
That is also my prayer, Mila. In the prayer also.
Mr. Parikh shall also take instruction whether the said contemplated tribunal can adjudicate the dispute arising for four separate agreements relating to the same work. The reference of the agreements are clearly provided in the petition. Next.
16.
Politics in 16.
Item number 16.
None appears. When the matter is taken up, let the matter be listed on 8th September. It is made absolutely clear if on that day there is no representation or the steps as suggested by the registry or the defects are not removed, this court will be compelled to pass an order for non-prosecution. Next.
17. Item number 17.
Same order.
18. Item number 18.
If I may please, your lordship. Item 18, lordship, the arbitration clause is at page 13.
It is a fresh application.
Yes, your lordship.
Yes.
Yes,
This is page 18 is a part of a legal notice.
13, your lordship.
30.
13.
13.
Yes, your lordship. The fourth clause, your lordship.
Notices.
Notice, your lordship, is at page 20, annexure 4.
All right. Heard Mr. S.S. BL and counsel appearing for the petitioner. There is a petition for referring the dispute to the sole arbitrator under section 11(6) of the Arbitration and Conciliation Act. In the agreement, there is arbitration clause for appointment of the sole arbitrator in the event of emergence of the dispute within the parties. The petitioner has served the notice demanding the resolution of the dispute and also for appointment of the arbitrator. No positive response has been received from the opposite party. So issue notice, same date, 15th September, take steps within 3 working days.
Much of it.
And the defect shall be removed by next 3 working days.
Yes, sir.
Much of it.
19. Item number 19.
None appears and the matter is followed. Let the matter be listed on 8th of September 2023. It is made absolutely clear. If on the day there is no representation, this court will be persuaded to pass an order for non-prosecution. Next.
21.
My lord, I appear on VC, my lord.
Yes, yes.
There is an application filed under section 11 of the Arbitration Act, Arbitration Conciliation Act 1996. The petitioners, along with the respondent, they had a partnership that is.
You straightway come to the arbitration clause in the partnership deed.
Then there is page number, running page 14 may kindly be seen, my lord. Running page 14, clause 16. That is the arbitration clause, wherein it say that in case of any dispute or difference of opinion among the partners with regard to any matter connected with the terms of this partnership or the business of the firm, the matter shall be referred to the arbitrator unanimously elected by the partners, and the decision and the award of such arbitrator shall be final and binding on the partners. So here, the petitioner had issued a registered notice to the respondent. That is running page, your lordship, I will draw your kind attention to the running page. That is 16 to 20. 16, my lord. And the last part, that is
Now running page and notice, I think 23.
27, 6, 23, my lord. So page 6 of that particular notice, your lordship may kindly see, wherein it is clearly mentioned, this is therefore to give you this final notice, calling upon you to come forward to sit across the table, render true and correct account of the accounts for an amicable settlement of the issue or dissolution of the partnership within 1 week of receipt of this notice, failing which my client shall have no other option but to take suitable legal action in the matter, to refer the dispute to arbitration in accordance with the arbitration clause in the agreement, and in such an event. So notice for arbitration was also served on the other side, was not responded to the same positively.
Yes.
So therefore, the present petitioner has no other alternative but to approach this honorable court for appointment of the arbitrator under section 11 of the arbitration.
You kindly read the arbitration clause.
Arbitration clause, my lord. Yes, sir. In case of any dispute or difference of opinion among the partners with regard to any matter connected with the terms of the partnership or business of this firm, the matter shall be referred to an arbitrator.
All right.
So that,
you are Mr. Murthy.
yes, my lord. Yes, my lord.
Heard Mr. T. Narayana Murthy, and counsel appearing for the petitioner. Since the effort of the petitioner has filed to get an arbitrator appointed on mutual, on consensus, to adjudicate the disputes that emerge from the partnership deed.
Yes.
Annexure 1 to this petition. This application under section 11, 6 of the Arbitration and Conciliation Act has been filed. Issue notice, returnable on 15/9/2023. Steps to be taken for service of notice on the opposite party within 3 working days from today.
I will take one.
Huh?
I will take one.
And within 3 days also, you remove the defects.
Beg your pardon. I have-
Defects as identified by the registry shall also be removed within 3 days, next 3 working days.
Sure, my lord.
24.
Your Lordship, I am appearing for the opposite party in this matter.
Yes.
Lordship, this is a matter for the appointment of the arbitrator. However, the former arbitrator had passed an award, Your Lordship. That award was challenged under section 34. The district judge set aside the award and remanded back to the arbitrator, the same arbitrator.
but the said arbitrator refused to entertain that arbitration. In meantime, we approached under section 37 before this High Court, and the order of the district has been stayed. In view of that, your lordship may
The stated is a
the
premature.
interim is continue. Section 37 petition is still pending there, lordship.
So it is a premature application.
Yeah, lordship. I'm for the opposite party.
Why are you filing? This is a premature application. Take back the application and file in proper application. You do not know what will be the result in the appeal. So take back this application. Get my point.
Lordship, I'm just forwarding this order, interim orders.
It is first.
Your lordship may see
What
order.
is your good name? You are on record?
No, your lordship. Miss Pamirat.
What is your name?
Pratyashish Mohanty, your lordship. Appearing on behalf of Miss Pamirat.
Mr. Satyashish Mohanty, Learned Counsel, appearing because Ms. Roth now has become a senior counsel.
Yes, your lordship. And she is the only counsel on record, your lordship, right now.
So there is Mr.
JP
Anna Raut, Mr.
Inner Raut is no more alive.
JP Behra.
He is not associated with with this chamber.
Counsel appears on instruction of Ms. Bobby Roth, and senior counsel, who is appearing with the opposite party. What is the line you have taken? Just read out the line. Counsel's name is there. Has appeared in instruction of second zone and submitted that in the proceeding under section 34 of the Arbitration and Conciliation Act, the arbitral award was set aside, directing to commence the press proceeding, but the said order of the district judge setting aside the arbitral award has been challenged in an appeal under section 37 of the Arbitration and Conciliation Act 1996, being ARBA number 57 of 2018. Stop. Mr. Mohanty has produced the order dated 23/3/2023, passed in the said appeal, being said appeal. Stop. From the said order, it appears that there is an interim order staying the operation of the order passed by the district judge under section 34 of the Arbitration and Conciliation Act 1996. As such, this petition is premature, and accordingly the same is disposed of, having stopped. But the liberty will be reserved in favor of the petitioner to approach this court on the basis approach this court subject to the outcome of the said appeal. You will may appear. What is your good name?
Your Lordship, on behalf of Mrs. Sumitra Mahanti.
All right. What is your name?
Soumya Sarthidas. Soumya Sarthidas.
Soumya Sachi.
Sarthi.
Soumya Sarthidas, Learned Counsel, appears in instruction of MS Sumitra Mohanty, Learned Counsel, for the petitioner. So it is disposed of. Given liberty after the outcome of the appeal, you can approach this court again if required. Next.
25 Millers. I am for the respondent Millers. Opposite
Yes.
party Millers. It's covered by one Supreme Court judgment. Kindly taken up for next week, Millers. Next Friday, I will give that judgment, Millers.
Based on, you are appealing for the petitioner,
Opposite party, my lords, MCL.
Mr. Devraj Mohanty.
Yes, ma'am.
At the request of Mr. Devraj Mohanty, Land Council appealing for the opposite party, let the matter be listed on 8th September 2023. You are appearing for them? You are on. Huh? Mr. S. Divedi, Land Council appears for the petition. What, 8th is a problem for you? 15th of March.
36.
36. 26.
Your Lordship.
Yes.
Relating to that application, my learned senior has, sorry, learned sister has opposed that it is not registered, sorry, not stamped. But in view of that, your Lordship, the Supreme Court before. Tanjore bench has already been decided in conclusion 109. But here the case is that the Lordship can see Annexure 2, the agreement. Agreement was duly stamped. At page 19.
Yes. Oh, it is stamped already. What is the objection exactly?
It is duly stamped. And
just a minute, let me see what is the objection.
Your Lordship, our objection was that 100 rupees for a transaction of this financial value, this 100 rupees stamp paper will not be sufficient. My objection was that. My objection was that it is improperly stamped.
I have brought the Government of Jharkhand Revenue and Registration, my lord, may kindly see. So far agreement is concerned, stamp duty is 3.50, 3 rupees 50 paisa. It was the stamped on 100 rupees. And it was on the e-file. My lord, may kindly see the Government of Jharkhand Revenue Registration Land Reforms Department.
Agreement where?
Clause 2, Your Lordship. Clause 2. Senior is referring to clause 2.
Clause agreement.
Agreement is a 3.50.
Yes, 3 rupees 50 paisa. Stamp duty. For registration is 2000. Any agreements.
Yes.
Subsequently, bond and conveniences will be defined. And so far the stamp duty and revenue audit manual is concerned, my lord, it is not, they have categorically stated in so far the agreement or memorandum of an agreement, it is the stamp duty and registration fee of the Jharkhand state of Ranchi, sorry, state of Jharkhand, they have stated that exemption clause, agreement or memorandum, there is no fee. The Lord's mechanism, I have to make it quite much.
There is no registration fee. But this is the
But that is registration is.
I mean to say that there is another the clause is there regarding stamp duty.
Stamp duty. So far stamp duty is concerned, my lord, that is 3 rupees 50 paisa. Here the Honorable Supreme Court in that conclusion paragraph.
Only one instrument. An instrument to the instrument.
It says generally it is 1.60.
Yes. And so far you are saying that conclusion paragraph, Honorable Supreme Court in paragraph 115, we further hold the provision of section 33 and the bar under section 35. Applicable to the instrument chargeable to the stamp duty under section 3 read with the schedule of the Stamp Act would render the arbitration contained in such instrument in non-existent unless the instrument is validated under the Stamp Act. If, my lord, there section 33, and so before that
subsection 14 of section 2, instrument, because the agreement has not been defined in the stamp act. So for instrument, the instrument includes every document by which right or liability is or forced to be created, transformed, limited, extended, extinguished, or recorded. Here an agreement has made in view of section 7 of the Arbitration and Conciliation Act, where the clauses for the arbitration was there.
Yes.
Milord. But the divergent view has been given in the Vidya Dorlia's case, also that SMS case, T-state case, for which it was referred third judgment. Third judgment opined that in part that is not at all applicable. Subsequently, it is referred to the larger bench. Even though the majority view has said that stamp is necessary. In view of the Jharkhand rules, it was stamped. That was my learned sister's objection. Other parties concerned, he is admitting that he has a claim. She has a claim of 6 lakhs. It is also admitted in the objection. But my humble submission that
it should be referred.
Yes. Referring 11.6.
Your Lordship, I would still stand by the fact that the document was improperly stamped. My senior is constructing the document as an instrument.
A little closer to the microphone.
Your Lordship, my senior is referring the agreement to be defined under as an instrument. Your Lordship, I cannot speak louder.
I understand. Already make it on the 8th.
Yes, Your Lordship.
8th of September. Marking it is a part third. Part third for continuation is the matter on 8th of September. Mr. T.K. Mishra. And counsel was appeared for the petitioner and Miss Benny Mishra and counsel is appeared for the opposite party. All right, it will come on 8th.
Yes, sir.
37.
Spotted for continuation of hearing, huh? Keep it on record. It may be raised, they may be referred again.
I'm appearing, Lord, on behalf of the opposite party, National Law University. We have filed a counter affidavit. They are supposed to
Who is appearing for the petitioner?
Beg pardon, man.
Who is appearing for the petitioner?
Petitioner, I don't think anyone is appearing.
Mr. Gaurav Gupta is from outside.
Outside.
If fixed on 8th, none appears for the petitioner when the matter is taken up. Mr. P.K. Rath, senior counsel, listed by
Mr. Romi.
What is your good name?
Mr. Adhiraj Behra. He power
Mr. Adhiraj Behra, and counsel for the opposite party. It is made absolutely clear that if on the next day there is no representation for the petitioner, this court will be persuaded to pass an order for non-prosecution. Yes.
29.
And may I please your lordship submit virtual mode, and for the petitioner last occasion your lordship has specifically directed to supply solve the counter affidavit.
We have a copy, but because there is no number, nothing, you cannot pay. It's because we have a copy. Neither contact number there, mail ID there. That's why not. If my friend will ask anybody to collect, you can immediately take it.
Because they are finding difficulty, either you share your email number with Mr. P.K. Pari, or you just request one of your friend who is practicing in this court to collect the copy and send it to you.
And SK Kanungo, the available is there, my lord.
SK Kanungo is there.
Ask him to collect a copy, I will give.
You ask Mr. Kanungo to collect the copy.
My lord, my lord.
Yes, let the matter be listed on 8th of September 2023. In the meanwhile, Mr. R.K. Sathapati, learned counsel, shall arrange collecting the copy of the counter affidavit filed by the opposite party. Mr. P.K. Pari, learned Deputy Solicitor General of India with Mr. Kashyap is not there. Who is it?
Kashyap is
All right, your name.
suffering here.
Appears for the opposite party. Okay. Next.
Item number 30.
My lord, I am for the opposite party, my lord. I am from virtual mode.
I am for the petitioner, your
Yes.
lordship. So the arbitration clause is at clause 17, your lordship, as page 26.
Okay. Are you prepared? You are taking up the matter for disposal. Learned counsel, are you prepared?
So they have filed their counter and they have not
But
disputed.
he is not audible. Check up whether. Mr. Mahapatra, can you hear me?
Yes, sir.
Are you ready for disposal today?
I have no objection.
All right.
So
Make
the
your submission.
amount, yes, sir. My claim is regarding reimbursement of the escalation charges and other charges, which is at page 109, reimbursement of extra expenditure regarding the pending payment and price escalation.
Yes.
The entire claim is around 7 crore 12 lakhs, your lordship. The arbitration clause is at clause 17 as page 26.
What
And
is
that
that?
not page 26, your lordship. Clause 17, page 26. Lordship,
What is your notice?
pardon, your lordship.
What is your demand notice?
My notice. Your lordship, may kindly see page 118. Page 118 to page 122. There are various communications rendered by me seeking appointment of arbitrator, your lordship. Page 118, kindly be seen. This is my first letter dated 19th April 2022. The last para, may I read, your lordship? You are kindly requested to appoint an arbitrator for redressal of our grievances under the relevant section of the contract agreement, your lordship. This is the first letter I have given on 19th April 2022. Thereafter, on 15th May 2022, I have written another letter. The relevant portion is at page 120, your lordship. The last para, as the office has denied all the claims made by the firm and no possibility remains conciliation as per the provision of part 3 of the Arbitration Conciliation Act, as amended by so-and-so, it is requested that under clause 17 of the volume 2 of the contract, Chairman CMD of Engineering Project Limited be approached to appoint an arbitrator for redressal of the grievances. This is the second letter. Another letter, your lordship, 19th May 2022, page 121, your lordship. The relevant portion would be as page 121, paragraph 5. It is submitted that the person to be appointed as arbitrator shall be an independent person. This is a request for appointment of arbitrator, your lordship. And the amount they have disputed, your lordship.
Where have you calculated the demand, the money that you have demanded?
Pardon me, lordship?
Where have you calculated the money that you demanded?
Yes, sir. Page 8 of my brief, your lordship. Running page 8. Page 8, para 17, your lordship.
But is in the notice reflected in the notice?
It is not reflected in the notice. The amount has not been reflected. The different heading of the claim has been reflected in the notice, but the amount has not been reflected, your lordship.
7 crore 12 lakhs 22. That
Yes,
is
sir.
the amount. Okay. Yes, Mr. Mahapatra.
Yes, my lord. My
Yes.
submission is that this application is a premature application, my lord. The lordship knows when the matter may be referred to the arbitration. Arbitration, referring the arbitration, dispute the basic ingredients required. And disputes comes when the demand has been made. They have not made a demand at any moment. That such and such amount, making the details of that amount as required to be paid. They have not made such demand. Secondly, my lord, your lordship shall look to page 27, the arbitration clause, where the jurisdiction has been stated that the Mumbai court alone has jurisdiction. 27.3. Page 27 of their brief.
Yes, yes.
Lordship, to that effect, I filed, kindly see my rejoinder, Lordship. Pursuant to execution of the contract, the parties had entered into an memorandum, Lordship.
Yes.
Lordship, may kindly refer to Annexure 6 at my rejoinder affidavit at page 5. This is the memorandum. This is a typed copy of the memorandum I've given you, Lordship.
Okay.
The original copy is at as given there under your Lordship. At page 6, Roman 16, your Lordship, arbitration as per the additional condition of the contract, jurisdiction, courts of Mumbai / Bhubaneswar, your Lordship. The Odisha High Court does have the jurisdiction, your Lordship.
There are also these Bhubaneswar, the courts are
Yes,
mentioned
my lord,
there.
in the memorandum that has been reflected, my lord. Accordingly,
Yes.
if your lordship shall accept, an appointment may be made.
It is a flexible clause. These are to be. Do you have any objection relating to the site of arbitration?
My lord?
Do you have any objection regarding the site of arbitration? Arbitration will be held in the arbitration center of the High Court of Orissa.
Yes, yes, I have no objection.
So we refer the matter, get it resolved there.
Yes, ma'am.
Because in the notice I have pointed out the no money has been calculated, but the claim basis of the claims have been provided in the notice.
Yes.
All right.
Lordship, since the amount is high, may I request any retired justice may be appointed?
I am appointing a retired Supreme Court judge.
No, it's a 7
Are you
crore.
happy?
No, no.
Huh?
No, Lordship.
It's all right.
Sorry.
May I suggest one thing, my lord?
Yes. Yes.
My lord, the SC Parijat, retired judge of the Honorable High Court, may be appointed.
No, we are appointing the former Chief Justice of this High Court, Justice Adarsh Goel. Any objection?
No.
All right.
Amount would be too small for him, sir. Amount would be too small for your Lordship.
His Lordship.
His Lordship.
So, who else can be appointed?
As my learned senior suggested, Mr. Parija, I don't have any.
SC Parijat.
Justice Parija.
All right. Heard Ms. S.L. Devi, Learned Counsel, appearing to the petitioner. Also heard Mr. J.K. Mahapatra, Learned Counsel, appearing to the opposite parties. Stop. This is an application under Section 11, within bracket 6 of the Arbitration Conciliation Act for appointment of the arbitrator for adjudication of the dispute as raised by the petitioner in various letters, part of the Annexure 4 series. So, for purpose of reflecting on the nature of the dispute, we may refer the you mentioned para 16. Yes, you may refer the paragraph 17 of the petition. Stop. In para 17, the petitioner has framed the dispute in the following terms, quote. Is page 8 of the petition. A, small a within first bracket, amount claimed on account of addition of piles, dash rupees 2,88,49,737.85. B, cost of additional steel, RCC and shuttering due to uneconomical design, as well as idling of resources due to delay in handing over the design and drawings, change in scope of work midway due to change in design and drawings, and arbitrary decoupling of firefighting works, dash rupees 4,23,72,567.00. So the total claim amount comes to rupees 7,12,22,304.58. Stop. Mr. Mahapatra, Learned Counsel appearing for the opposite party, has submitted that in the agreement, the dispute is in terms of the agreement, disputes are supposed to adjudication within the jurisdiction of Mumbai, but in the subsequent memorandum, the Bhubaneswar has also been included. Stop. This is a matter of arbitration.
My lord, another aspect, another ground, my lord, there is no demand at all. The demand has not been made.
Yes, sorry. Mr. Mahapatra has also pointed out that though the several notices have been issued, but the demand in terms of money has never raised. Only that has been raised in the petition. Stop. Having appreciated the rival contentions, this court is of the view, though the demand has not been monetized, has not been reflected in monetary terms, but the foundation of the claim has been well laid in the notices. Therefore, in presence of an arbitration clause in the agreement, we appoint the sole arbitrator to adjudicate the dispute and pass the awards within the time stipulated under Section 29A of the Arbitration and Conciliation Act 1996. So, Mr. Justice S.C. Porizia, Justice retired, S.C. Porizia, a former judge of the High Court of Orissa, is appointed as the sole arbitrator. Stop. The arbitration proceeding will be carried out under the aegis of the Orissa High Court of Orissa Arbitration Center. So a copy of this order be sent to the coordinator, Orissa High Court Arbitration Center, for taking the necessary steps. Stop. This all right. More things required to be mentioned.
Pardon, Monsieur?
Any more things are required to be mentioned? No. All right.
Much obliged.
Accordingly, this application stands allowed and disposed of. Yes, next.
31.
Much obliged.
I'm on VC Milan. I'm on VC Milan.
Yes.
Here the opposite parties have already filed that counter which has been received 2 days back. I will file my rejoinder, Milan, if you kindly permit me to file rejoinder.
If I fixed on 8th of September, it will be okay for you?
Yes, Milan, it can be. No problem.
All right. At the request of Mr. T.N. Murthy, Learned Counsel appearing for the petitioner, let the matter be listed on 8th of September 2023. Meanwhile, the petitioner is permitted to file the rejoinder if any. No further accommodation for the purpose shall be made by this court. Mr. A.K. Mistral, Learned Counsel appears for the opposite party.
Much obliged.
32.
Item 32 on behalf of Mr. S.S. Kashyap, madam. And on behalf of Mr. S.S. Kashyap, madam, he is suffering from dengue. I humbly pray for adjournment, man.
All right, you are
I am
appearing for the opposite party.
Petition. I am for the petition. It's for OP.
All right. And the request made from Mr. S.S. Kashyap and counsel appearing for the opposite party. Let the matter be listed on 15th September 2023. Mr. S.P. Mistral and counsel has appeared for the petition. Next.
33.
33, my lord, I am for the petitioners.
No, 33 before my learned friend. 33, 34, these two matters. Previously, I had once taken adjournment for filing of a reply. My reply is almost ready, my lord. Lordship may take it upon 8th, I will file reply.
The request of
33, 34,
Mr.
once I had taken adjournment.
P.K. Rath and the senior counsel appearing for the
Mr. Bayer.
opposite party. Let the matter be listed on 8th September 2023. Meanwhile, the opposite parties may file the counter affidavit. No further accommodation will be made. Mr.
Adhiraj Behera.
No, I am not. Who is appearing for the petitioner?
Yeah, petitioner, myself, PC Panda. PC Panda.
All right. Mr. PC Pandal and counsel appears for
Same
the
prayer
petitioner.
for
If 34 also,
33, 34, 40, 41, 42 up to 43, man.
just already, in all the matters, Mr. Panda, you are there.
Yes.
Already the same order. Have you taken the note? What is the matter? Just Mr. Roth, just repeat these item numbers.
33, 34.
Item numbers.
Item numbers. Then 40, 41, 42 and 43. Right, Millard? The next item 44 to 45. I am
Just
filing my
recently,
counter to
they have solved the counter.
Yes. Today I am filing my counter. I have solved
Already your 8th will come in the meanwhile you file the
right?
counter.
No, I have already filed it.
All right, in 1034, Mr. 44 and 45.
44 up to 48. Today I am filing counter. Let's say.
Letter bears, huh?
6 matters, my lord.
Mr. Roth, the Senate counsel has informed this court. The counter affidavit has been filed today. Yes.
Can I just make a request, ma'am? But since other matters are fixed to 8, can these be matters be splitted up to 15 matters so that
letter party we can instead of 8, make 15 September. Okay?
So that will be easier on my part to
all right.
Grateful.
My lord, last items starting from 43 to 48, when it is
15th.
It will be very difficult for me to file the rejoinder for that.
So you are getting clear 15 days time. File it on rejoinder.
20 seconds.
Otherwise, any difficulty will accommodate you.
My lord.
Yes. Yes. Item?
Item number 35.
Item number 35, your lordship, I am appearing for the opposite party.
Yes.
It called ferrochrome and alloys. I am appearing for the opposite party. It called ferrochrome and alloys limited.
Okay.
OP 2 and 3, your lordship.
You have not filed any counter affidavit? Will not
Lordship, actually it was listed for filing of a substitution petition. The it called ferrochrome alloys and limited has been merged into Odisha Mining Corporation. So there is a
all right, yes. The substitution petition in terms of the order dated 11/8/2023 has not been filed by the petitioner. There is no representation even today in the proceeding. You are Mr. Mohanty, P. Mohanty.
Yes, your lordship.
Mr. P. Mohanty and counsel has appeared for the opposite parties.
In this matter, the state has filed an IA number 12 of 2023 for deletion of the name of the opposite party number 1. Because the opposite partner was not a party to the agreement.
Can I have a copy of this petition because it has not been scanned and uploaded?
Yes.
We have also not received any copy.
See now. Because you are appearing for 2 and 3.
2 and 3, your lordship.
Yes, they are appearing for 2 and 3. Yeah. Mr. P.K. Mudoli, London. Additional government has appeared for the opposite party number 1 and stated that the said opposite party has filed one application for deletion, as they have nothing to, as the state of Odisha has nothing to do in this dispute.
Only my office copy is there.
Then I will just return you.
Yes.
Just take down I number 12 of 2023. They have just only stated that the department you have made party, they are not concerned department. Other department concerned, I am deleting the present department and incorporating the department they have named.
Your Lordship, any other petitioner will reply to it.
You have no interest because it's a petitioner concern. Petitioner has made the
Your Lordship.
request.
Your Lordship.
Just it has been stated in this petition that the state of Orissa in the Department of Industry nothing to do with the present dispute, and accordingly the opposite party number 1 shall be deleted. But from reading of the petition, it appears that the Steel and Mines Department, Government of Orissa,
That state is, no department is required to be made a party. Because the agreement was executed with the opposite
I
party.
observe that it is not required, their presence is not required.
Yes. It's a
It
contractual
has been
dispute between
revealed
two
that
parties.
That matter is remotely connected to the administrative control, connected to the Steel and Mines Department. But in our view, the opposite party number 1 is not a proper party, and accordingly, opposite party number 1 stands deleted. In the result, this application is allowed and disposed of. Registry is directed to scan the application being I number 12 of 2023 in the digital record and place the same in the digital record. So we have deleted 1. Is it? The rules of executive business has nothing to do. If you are a part of the framing of the agreement and funding, you may be remotely collected, but I have find no such abamment also in the petition. So you are deleted. Okay, and the result of the application is allowed and disposed of. Yes. It has been listed on 8th, no? So fixing on 8th September.
Let it come on 15th, Your Lordship.
Just a main petition, the first part of the order, is the matter on 15th September 2023. It is made absolutely clear if on that day there appears none for the petitioner, this court may be compelled to pass an order for non-prosecution. Yes, close it now. There is a break bench is there. 345. Investor sound. Another 15 minutes.
Grateful, Your
36.
56, my lord. Lords, you may kindly see the noting. Well, notice is insufficient in this case, my lord. A noting is there left without information, my lord. Lords, you may permit us to take fresh steps to issue.
So takes first step.
We'll have the notice on the correct address, my lord.
You are Mr. A. Mohanty.
My lord.
Mr. A. Mohanty and counsel appearing to the petitioner seeks accommodation for taking first steps where steps allowed. Let the matter be listed on 15th of September 2023. In the meanwhile, the first steps for service of notice on the opposite party be taken. Stop. It is needless to say the correct address should be collected first and then the steps should be taken. Yes.
37.
37, my lord, last occasion, I took time to file counter. No, I have not received the Faroese counts. There is some more time.
Last occasion also, at your instance, this matter was adjourned.
Yes.
You want to file the counter affidavit?
Yes.
So it is a 10th, 8th of September?
15th.
At the request of Mr. P.K. Madolil and counsel appearing for the opposite party, let the matter be listed on 15th September 2023. In the meanwhile, the opposite parties shall file their counter affidavit if any. No further recommendation for the purpose will be given. You are Mr. N.
Mr.
Ginger Singh.
Diptikant Bal.
Diptikant
Bal. PAL Bal.
Mr. D.K. Ball and counsel is appeared for the petition.
38.
My lordship, in item number 38, I am appearing for the opposite parties. Kindly grant 2 weeks more time to file the counter affidavit.
What is your good name?
SK Swine.
The request of Mr. S.K. Soil and his counsel appearing for the last occasion. Last time was granted earlier.
Last time.
Now this time it will be last chance. Let the matter be listed on 15th September 2023.
Obliged.
Meanwhile, the opposite parties shall file their counter affidavit if any. No further recommendation for the purpose of the given. You are Mr. J.P. Behera. Mr. J.P. Behera and counsel appears for the petition. And next
39.
is
Item number 39.
Appearing for the opposite party. There was an attempt to hasten at amicable settlement, my lord, but both the parties could not arrive at an amicable settlement. I only require some time to file my objection on the point of jurisdiction only.
all right. At the request of MS, you are there on record? No. Yes. Miss MS Apal and counsel appearing with the opposite party, let the matter be listed on 15th September 2023. Meanwhile, the opposite party shall invariably file their counter affidavit. No further recommendation will be made. None appears for the petition when the matter is taken up. Next.
49.
49. Yes.
May it please, my lords, I appear for the respondent, my lords, in this matter. My lords, I see.
How are you now?
Lords, I have recovered, my lords. Because of that reason, lords, I could not file my reply. If your lordship will kindly have the matter on 15th, subject to your lord.
15th September, okay.
My lord, on behalf of Mr. Amita Pradhan, my lord, the objection has not been received.
It's already, he's also, Mr. Sashwat also praying for time. So 15th September will be the date. At the request of Mr. S. Acharyal and counsel appearing for the opposite parties, let the matter be listed on 15th September 2023. Meanwhile, the opposite party shall invariably file their counter affidavit as no further accommodation will be made. What is your good name?
Deepak Gochayat.
Mr. D. Gochayat and counsel appears an instruction of Mr. Amitabh Pradhan and counsel for the petition. You are there on record? No.
No.
Obliged.
Is
the case of appointment arbitrator. But I examined the record, it was found that he is only claiming that service tax of the GST, all these things. So it is not covered under the clause 25 of the Arbitration Act because it is a different dispute. If any claim is there about the government taxes, then he can invoke this jurisdiction.
No, all right. Section 25 you read carefully.
Yes.
Because I don't know how they have raised the dispute.
Yes.
If it is a part of the agreement, that can be the referable dispute. But
Yes,
if it is not a part of the agreement, that takes a separate color.
My lord.
Yes.
This
25 is a default of a party.
Yes.
This is in the proceeding. So what is the clause in the agreement regarding
Agreement is clause page 49, 25, clause 25.
25 is the agreement, arbitration clause laws.
Now,
And the
regarding
arbitration clause, settlement of the
mean to say
dispute and
not the- I
arbitration.
am not right at this point concerned.
As per clause 25, Lordship, I approached the DRC.
No, my issue is that what is the contract between payment of this tax or the future tax, whatever? Is there any contract?
Lordship, in contract. that is
Because
clause.
dispute must be relating to the contract only.
Lordship,
You cannot bring the outside dispute within the domain of the contract.
Lordship.
So where is that order regarding, where is the clause in the argument regarding the payment of the
In
tax?
this proceeding, I have filed just relevant pages. Lordship, next day I will file entire GCC. In GCC, there is clause.
8th is okay? 8th September?
Yes.
All right. At the request of Mr. J.P. Beral and counsel appearing for the petitioner, that the matter be listed on 8th September 2023. On that day, the full agreement shall be produced to show that the incidence of tax or the accessible tax have been required to the agreement, and there the liability has been created against the opposite parties. Stop. Mr. P.K. Pari, and Deputy Solicitor General of India, has appeared for the opposite parties. That's all. Special list matter we are dividing between the 2 days, 8 and 15. Half of the matter will be listed on 8th and rest of the half will be fixed on 15th. So take the date from him. You give the date just.
Is the husband and the case was filed for the restoration of conjugal life. For no cause, no complaint, no dispute, the wife has been gone for the baby birth and she not returned till yet. And in the court below, they have also filed this, did not receive the notice. And on 25th, it was last order of this honorable court to file requisites. I contacted the client and he told that I won't like to spend any time, money and effort to call back her. If she is not coming, let this matter may kindly be withdrawn. Yes, my lord.
So this
On 25th also a withdrawal memo is filed, but it is not mentioned in the noting. So I am fresh withdrawal memo is I am filing.
He has filed a withdrawal memo, so ask the no, I'm giving another, all right.
All right. Miss Hiron Raut, current counsel appearing for the applicant, has stated that she has instructions to withdraw this application. So in this regard, an memorandum for withdrawal has been filed, which is, and the same is taken on record. So in view
I'm obliged.
Stop. In view of the this above statement made by Ms. Raut and counsel, this application stands dismissed for non-prosecution. No, dismissed as withdrawn. All right.
My lord, item 2, I am appearing on behalf of Mr. Saurabh, my lord. My lord, I am for the petition, my lord. My lord, on the last occasion, your lordship has adjourned this matter, awaiting the order from the Honorable Apex Court, my lord. But till date, no decision has been taken, my lord. My lord, may grant 4 weeks time, my lord.
You said that it would be listed in the first week of August 2023.
Yes, my lord, we are trying to get this matter listed before the honorable.
Not yet list.
Not, my lord.
It will be very difficult to accommodate this way in council. Because if you do not approach the Supreme Court, showing the urgency that you have,
Yes, my lord.
ultimately you have to dismiss your petition.
Yes.
We are
Well-
giving you the last opportunity, fixing the matter in this October sometime.
Yes, ma'am.
13th October, we are fixing the matter. You are Mr. S. Shoram.
No, my lord, I am appearing on behalf of Mr. S. Swaram, my lord.
What is your good name, sir?
My lord, Tarini Prasad Tripathi, my lord.
Mr. Tarini Prasad Tripathi and counsel appearing on instruction of Mr. S. Shoram and counsel has submitted that the matter as pending in the, as filed in the, so this is SLP or appeal?
My lord, I am having the diary number, my lord.
Only diary number, no number.
So the appeal from the order dated 9/1/2023 as passed by the National Company Law Tribunal has not been as yet listed before the before the apex court, and as such no order has been passed. As such, they are not. It is, you do know whether it is listed or not.
My lord, it was last listed on 28th August, my lord. My lord,
No order has been passed.
no, my lord.
This just say the appeal was listed on 28th August 2023, but no order could be passed because the matter did not reach in the course of the day. Stop. Yes, a short accommodation has been sought. Best and let the matter be listed again on 13th October 2023.
Yes, ma'am.
In the meanwhile, it is expected that the petitioner shall place and record the order staying the operation of the said order passed by the Company Law Tribunal. Otherwise, this court will not provide any further accommodation.
3.
Gratefully, lords.
Please use the mic properly. It's not audible.
Yes.
I am filing the second copy as reported in the noting.
Keep it on file. Yes, Mr. Mudali, any objection?
But the beneficiary is Lord Jagannath.
Huh?
Beneficiary Lord Jagannath. Because in the writ petition, the claim of Lord Jagannath for settlement of the land in favor of the Lord under the provisions of OEA Act has been allowed. That has been challenged by the petitioner. Accordingly, last occasion, my lord issued notice to the temple administration.
They have not responded.
Someone has been duly served.
Check up the office note, nothing is there.
That justice summon received after valid service.
We are fixing it again on 8th September because it appears Dosti has been served on that.
The Dosti summon has been served. Dosti summon has been served. I have filed also affidavit.
That is there.
I will also intimate Mr. Satpathy, who normally appears for the temple administration.
It appears from the registry's note that by Dosti, the notice has been served.
No, can you give the full name?
Subrat Kumar Satpathy.
Subrat Kumar.
Stop. Mr. P.K. Moduli, Learned Counsel has submitted that usually for the opposite party, Mr. Subrat Kumar Sathapati, learned counsel appears. Stop. Mr. Sathapati will be informed. We request Mr. Mudali to inform Mr. Sathapati about this, about the date, next date. Mr. A.K. Tripathi, learned counsel, has appearing to the petitioner, has submitted that in support of the Dosti service, he has already filed the affidavit.
Yes.
On the next day, there shall be no accommodation.
Supplemental list, item number 1. Item number 1.
Then appears is the matter on 8th September 2023. It's made absolutely clear if on that day there is no representation, this court will be compelled to pass an order for non-prosecution. Next.
Item number 2.
Just now, I also been served with a copy of the IA filed by the respondent numbers 3 to 11. There are two errors which I have found out in the last order. That is why I have filed this. But the only thing is that I know my difficulty is only filed here.
No, that's you are also not aware that some petition will be filing. What orders sought to be modified?
Your Lordship, there are two errors which I made quite wrong. What is that? In the order dated, in the order dated 30/6/2023, Your Lordship, there has been written that in terms of the impugned award, each of the workmen was being paid with 2 lakhs as compensation in lieu of reinstatement. You are also supposed to consider last week that because there is no reinstatement, it is not that problem.
Yes.
I have pointed out that for correction of that particular word, Your Lordship, that reinstatement cannot be paid. And that is also my learned friend has pointed out in his petition that it is for back wages. But I have found out it is not also for back wages. They have said, the tribunal has said that they are not entitled to any back wages. But compensation they have given as a gratis. So that is one point, Your Lordship, that is to be deleted, reinstatement board has been deleted.
No, this is first issue
But
first.
what-
This is an application for restoration.
No, man, but I am submitting, Your Lordship. It's not my error, Your Lordship. So the error is from the registry, Your Lordship. I have appeared in the case since 2016, but my name didn't appear. On the day when the matter was registered and the matter was disposed of, as no instruction, I mean, the other previous counsel who was engaged, his junior said that the file has been taken away from us. That is how there was no appearance from our side. That is how this is the order. So it's a formal CM appeal loss. That is the only thing. But the only thing that whatever your loss wants to hearing the request, so I have no mind. And just be hard. Your request has not been hard.
Who is appearing to the opposite party?
We are for 1 and 2 only.
No, you have nothing to do.
No, because CGID just happened.
Yes.
I am appearing for opposition part number 3 to 11. So I filed by mistake, Your Lordship, IA. As my friend said, that I want to delete that word in lieu of reinstatement. I agree. As your lordship, last time sealed order,
Yes, yes.
the award I have quoted. Not be judged like if they are given back with it, but they are surely entitled to receive compensation. Persons considering all the facts surrounding I award rupees 2 lakhs to each of the disputed workmen as compensation. The dictates of the award shall be complied with. Hello. The passport manager matter of termination, let's but they are surely entitled to receive compensation. Lordship, it is not in lieu of reinstatement, it is in lieu of back wages. No. Lordship can already put on the hour.
No, so you have no objection if you restore the petition?
Yes.
First, we go to that part.
Sure.
Today itself it may be hard, but we have to first, there is a hurdle.
Yeah.
So we can restore this part.
My prayer, my lord, in mistake has stated.
Huh?
I have filed an IA today. For correction, I am appearing for the opposite part number 3 to 11.
Yes.
Except opposite part number 7.
Where is that order has been passed?
APRN.
No, this order 36/2023, in which case this order has been passed? Okay.
That is order number 4, your lordship, if I am not wrong. Order number 4.
All right.
5th line, your lordship.
The amount deposited may be released in favor of the workman. I said 35 years that is running, but not a 5 years.
May I pray, my lord? My lord, I am appearing for the respondent number 12, my lord. May I pray 1 week time to file objection to the CMPL?
CMPL?
Yes.
This
Your lordship granted last occasion.
Please don't make an unreasonable demand. If you file the objection, you know what will be the fate of the case. Right? Ultimately, on this ground for the lawyer's absence, we usually pay cost and certain thing, but we usually, because this is not the justice. Justice is on merit. So we try to accommodate all, and as for the 3 to 11 who are appearing, they are not opposing that way very strongly. They have agreed it.
That is there, 36/2023, it's in the 5th line.
I've got it. 30, not 6, 34.
36, your lordship, 2023. Order number 4.
Yes, order number 4. Oh, this is wrong.
Wrongly typed.
No, there's actually in our page mark this wrongly typed. 36. You are absolutely right. Okay. Heard, Mr. Informational and Senior Counsel is stated by A.K. Royal and Counsel for the applicant, as well as Mr. B.S. Raiguru and Counsel appearing for the opposite parties number 1 and 2, and Mr. Yes, Lakshmidhar Das and Counsel appears for these opposite parties 3 to 11, and Mr. Biswal.
Yes.
And Mr. S.N. Biswal and Counsel appears for the opposite party number 12. This is an application for recalling the order dated 11th July 2022, passed in WPC number. It is 3822, no?
I will double
5882 of 2012. By which the said writ petition was dismissed for non-prosecution. Mr. Learned Counsel has stated that the non-appearance is wholly unintentional, as his name was not reflected in the cause list. On the basis of the cause list stop, he has also stated that it escaped his notice as his name was not reflected in the cause list. You don't go into the other part. Stop. Mr. Lakshmidhar Das and Mr. Biswal did not raise any objection in setting aside the said order dated 11/7/2022 for purpose of restoring the WPC number such and such of 2012. Accordingly, this application stands allowed, and the WPC number such and such is restored to its original file, allowed and disposed of, and then it goes down, restored to its original file. Now you come to the WPC, or you want the correction in that order.
No, correction is in the CMA table.
All right.
Correction was in the order which was passed in CMA table. That is 36.
What is the award, Mr. Das? In the petition, no?
Starts from page 56 or 56 or 57.
46.
Internal page ಇಲ್ಲ
What they have done in oh, it is in the petition, no? No, it's checking of this.
Internal page ಇಲ್ಲ that is the last page of the order.
It is in the last paragraph.
Last one. Page paragraph 13 years. 1 3.
These pages are not all scanned. Your word part is not here. In your file, this word part. That is issue number 2. This is the award. Now, separately, award is not marked here. You have filed an application for correction. This application?
Yes.
All right. The opposite party's number 3 to 11. This is the I number has not been put. To collect the I number. You have not filed in the registry, so there is no I number now.
I have filed.
This one was.
My ID 269.
The same prayer. That is also not here. 269 is there. When have you filed the 269? 30th of August, that is right. 269 of 2023. By means of this application, the parallel investment and trading company, no, the opposite party is number 3 to 11. In same application, CM application, CM apply now 36 of 2020, 36 of 2020 has asked for correcting the mistake, a mistake error that has crept in order dated 36/2023. Similar application has been also filed by the petitioner, applicant, Parallel Investment Trading Company Limited, and another in the court, which is still unregistered. The said application is also taken on record. In the said order dated 36/2023, it has been recorded as follows, quote, in terms of the impugned award, each of the workmen was to be paid rupees 2 lakhs as compensation, then highlighted, in lieu of a reinstatement. The award was made way back in 2011, i.e. nearly 12 years ago. Stop. This word, unquote, this word in lieu of reinstatement is sought to be deleted. Stop. We have compared with the award passed in award annexure 7 to the WPC 5822 of 2012. Annexure 7. Stop. In the award, it has been noted that page 56. It has been noted that as the matter of termination relates back to the year 1988, nearly 23 years back, it will not be justifiable if they were given back wages, but they are surely entitled to receive compensation. So considering all the facts and surrounding circumstances, the presiding officer, CGIT cum labor officer, Bhubaneswar, CGLT, it will be LT, Industrial Tribunal cum labor court, Bhubaneswar has awarded rupees 2 lakhs to each of the disputant workmen as compensation. So therefore, the word in lieu of reinstatement is to be deleted, and accordingly it is deleted. So this order shall be made part of the order dated 30, is formed made of the order dated 36/2023. In terms of both the applications are disposed of. Stop. Now we fix a date for the hearing of the writ petition.
Yes.
When it can happen? 15th September. No, some other date you want.
Next meeting here.
8th of September.
8th and not there.
Oh.
It took 12th and not there.
No, other dates it becomes very difficult.
15th, 18th, or 21st, 22nd.
20. In WPC number 5/8/2020. Right. It will be there.
What's
All
the
right.
date it is? That's why.
Stop. This petition has been restored by the order passed today in CMLP number, which is there. Huh?
330.
Stop. We have heard the council for some time. Let the matter be listed on 22nd of September 2023 as parted for continuation of hearing. Name the councils. Name of the council is Mr. Rai Guru for 1 and 2, Mr. Das for 3 to 11, and Mr. Sadinsaj is for this at 12. Already Mr. Mishra and K. Mishra for the petitioner. And assisted by Mr. A.K. Roy. This 12 is Mr. S.N. Biswal. All right.
Lordship, item.
This building we have the material. It is better. Because my only constraint is instead of 4, it will be a little earlier. After it's a 2 and because it's taking some time.
Item number 1. Lordship, item number. Item number 1, my lord. I was like, Mr. But it says CMP for restoration. I beg apology for that is done.